For delivery of judgment. Number 31. PRP 64 of 2024. Orders item 1.
Wait, please. My lord, this is an application for delay of condemnation. Delay of 109 days calculated by the office. 119. 119 days. The service is complete, madam.
Yes, hearing for one. Any objection in the condemnation of delay?
My senior did not give any concern about
Your senior is not today, not present today. Who is your senior?
S. Moria.
Yes.
S. Moria.
When he will be available?
Next week.
Next week.
They have bought this by order, my lord. They have finally mentioned. This matter is listed by order.
That's all right. If he's
Can be listed any.
heard Mr. Batra, learned counsel for the applicant, and Mr. Your name? Learned counsel appearing on behalf of Mr. So-and-so. List the matter.
It will be up.
When?
Eight.
Okay.
Oblige.
So list the matter on it. So
Oblige.
Items 2 and 3.
May it please your lordship. Here, my lord, because of my misplacement of the brief, I could not provide him the copy. So I could able to trace the brief now. So I'll give him today. Copy was
heard
supposed to be.
Mr. Learned counsel for the appellant and Mr. Colito for the respondent. I assume submits that pursuant to the order dated 30/4/2026, she could not file the copy of memo of appeal to the learned counsel for the respondent, and she tries for when you will be able to furnish it
Course of the day today.
today. Miss Som submits that during the course of the day, she will furnish the copy of memo of appeal to Mr. Colita during the course of the day. List the matter after.
After graduation.
Okay, we'll list the matter for hearing then.
Yes, Lord.
For admission not yet admitted. The item 2 is not yet admitted.
Mr. Colita, learned counsel for the respondent,
Admission hearing also before.
submits that.
It may fix for admission.
After vacation.
Preparation is necessary before admitting in medical.
Why?
Basically, this is not maintainable at all.
Why?
The formal
This is first appeal.
Yes. The grounds, let you see the grounds in item number 2.
No. There is no question of admission hearing in this matter.
The grounds of your
That will be decided at the time of hearing, final hearing. It is to be noted here that this appeal under section 28 of the Hindu Marriage Act is directed against the judgment dated 3rd of September 2024, passed by the learned district judge Baksa Mosolpur in Mijje case number 2 of 2024. 2024. First, the memo of appeal and the grounds mentioned therein. And also first the impugned judgment dated 3rd of September 2024. Admit. Issue notice. However, no formal notice is required to be issued, since Mr. Colita has received the notice and entered appearance on behalf of the respondent. Justice will call for the record from the learned trial court and list the matter for hearing immediately after receiving the record from the learned trial court.
Deeply obliged.
Criminal petition is attached with it.
So I have not received a copy of the evidence, it's not provided copy.
Criminal petition also.
Well, it means for the respondent, but copy has not been provided.
Heard. Nice. So learned counsel for the applicant. Now for the petitioner and Mr. Polita for the respondent. Mr. Polita submits that he has not been furnished with a copy of this criminal petition. Ms. Som submits that during the course of the day, she will furnish a copy of the criminal petition to Mr. Kolita. Accordingly, it is provided that Justice shall list the matter for hearing. Whether record will be required here?
Yes, Lordship.
Justice shall call for the scanned copy of the record of MR case number 8 of 2018 from the learned trial court. List the matter after. Get it in. Matter. Okay. Justice shall list this criminal petition along with matter bill number 44 of 2024 immediately after receiving the record from the learned trial court.
I'm obliged.
Item 4.
May it please your lordship. Your lordship, in this case, respondent number 1 has already entered appearance. And as per office note dated 29/5/2026, respondent number 5 has also filed his wakalatnama. And as regards respondent number 2, 3, and 4, there has been struck off, your lordship, by order dated 6/2/2026. The service is completed, your lordship, and as here has been received.
Third, Ms. Bhattakur, learned counsel for the appellant. Mr.
I'm for number 1.
Mr. Talukta for the respondent number 1. Mr. Pegu for respondent number 5. Ms. Bhattakur submits that service in this matter has been completed. And the LCR has also been received. And as such, the matter may be listed for admission or no, for hearing. Accordingly, it is provided that registrar list the matter for hearing in usual course.
Obliged.
Item 5.
Appear. But appear.
Service completed.
And teacher come.
TCR has not been received. Heard Mr. Zayamil, learned counsel for the appellant, and Mr. Devi for the respondent number, sole respondent. Office note dated 29/5/2026 indicates that no TCR has been received. Registrar shall issue urgent reminder to the learned trial court for transmitting the record and list the matter immediately after receiving the record from the learned trial court.
Item 6.
May I please be lordship? Lordship, according to office note dated 29/5/26, postal tracking of R1 is complete. Respondent number 2 is represented by Pro Wakalatnama, and service is complete. Lordship, reminder for LCR may be issued.
Heard Mr. Agarwal, learned counsel for the appellant. None appears for the respondent number 2. Office note dated 29/5/2026 indicates that notice upon respondent number 1
Yes.
has been delivered. As per postal tracking report. And the said office note also indicates that LCR is awaited. In view of above, Restis shall issue urgent reminder for the learned tribunal for transmitting the record. List after
Vacation,
vacation.
Lordship.
Item 7.
May I please your lordship?
Yes.
Lordship, the steps could not be taken due to some difficulty. Kindly allow us to take the steps.
Heard Miss
As thus,
as does learned counsel for the
Elal.
appellant. Learned counsel appearing on behalf of Mr. Ayala, learned counsel for the appellant. Office note dated 29/5/2026 indicates that no step upon respondent number 1 and 2 have been taken. Learned counsel for the appellant submits that she may be allowed to take step upon the respondent number 1 to 2. They are allowed. Step be taken by speed post and also by usual process within a week from today. List the matter. The SSL also issue reminder to the learned tribunal for transmitting the record. List the matter after for its.
Oblige your lordship.
Item 8. Back to the lordship. Now that we had filed a joint compromise petition. But lordship, I'd like to refile it. There's some omission. You will not press this, I'll file, I've already refiled the case.
Pardon?
I'll file a joint compromise petition, go to pass.
Refiling,
Refiling.
we are not
There's
pressing
some
this one.
mistake here.
We are not pressing this one, lordship. This may kindly
Whether
be,
the appeal is admitted for hearing.
In the year.
no. No, no. Delay condon ko delay condon ko delay condon kori ko lagbo condon kora na
Delay lord.
delay may can
No, Mr. Goswami, you say some
He's appeal lordship.
my opinion.
appeal is yet to be admitted. How can we pass this kind of orders?
But lordship, we are doing this in
You are
initially
doing this all right, but whether it has the sanctity of law,
technically wrong, lordship.
technically wrong.
But
Then
today
why you are insisting upon it?
delay may kindly be condoned, lordship.
Mr. Agarwala, learned counsel for the applicant. In IA civil number 1107 of 2026 submits that he is not going to press this interlocutory application.
Obviously,
And accordingly, IA civil number so and so stands closed. What is the ground for delay?
3, 4, 5, lordship. Prayer number 3, 4, 5.
Mr. Goswami, do you have any objection?
No.
Heard Mr. Agarwal, learned counsel for the applicant, and also heard Mr. Goswami, learned counsel for the respondent number 3. Mr. Goswami, you are for the respondent opposite party number 3. Whether notice was served upon respondent number 1 and 2?
That for delay stage in court below also they were expert lordship. So then they make and stock over.
Office note dated 7/4/2026 indicates that notice upon respondent number 1 to 2 could not be served. However, Mr. Agarwal, learned counsel for the applicant submits that respondent opposite party number 1 and 2 did not contest the MSC case number 2748 of 2017 before the learned tribunal. And as such, their name may be struck up from the array of this appeal. Accordingly, taking note of the submission of Mr. Agora, learned counsel for the applicant, the name of respondent opposite party number 1 and 2 are struck up from the array of this application at the cost and risk of the applicant. Mr. Agora, learned counsel for the applicant, submits that this interlocutory application is preferred under Section 5 of the Limitation Act for condonation of delay of 54 days in preparing connected MSc appeal against the judgment and award dated 4/4/2025 passed by the learned member, Motor Accident Claim Tribunal number 2, Kamrup M. Gauhati, in MSc case number 2748 of 2017. Mr. Agora, learned counsel for the applicant, submits that the applicant, sir, illiterate and rustic blazers, and they are not aware of the filing time. About the period of filing, about the period of limitation in respect of filing the appeal. And also there was financial constraint. And as such, the appeal could not be filed in time. And there is the delay of 54 days, and the same is not intentional. Rather, it is circumstantial, and under such circumstances, he has contended to condone the same. Mr. Goswami, learned counsel for the respondent opposite party number 3, submits that he has no objection in the event of condoning the delay. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanation so put forwarded in paragraph number 3, 4, and 5 of this application, this court is of the view that the delay has been sufficiently explained and accordingly the same stands condoned. In view of the order passed in this interlocutory application, now the registrar will register the appeal and place the same before the court as soon as practicable.
Next week, Lordship. This compromise petition, I have to remind myself. We are not pressing this compromise petition, Lord. That is events. That has not come, na? Next week, Lordship, admission. Admission. And our name may kindly be shown in the post.
Okay. Registrar shall reflect the name of learned counsel for the appellant and also the
And
respondent in
respondent.
the cause list.
Much of that. Because for hearing. Number 9, quarter meter.
My senior is next, number 5.
Nine. Ordered matter. Mayadas.
Okay, after some time. Let us senior come.
Items 10 and 11. Quarter meter.
May I please, your lordship?
Yes.
My lord, when this item was taken by your lordship on 21/4/2026, and after perusal of the judgment passed by the first appellate court, your lordship was convinced that the first appellate court has neither framed any points for determination, nor my lord has discussed the matter issue-wise. Only issue number 1 and 4 was discussed by the first appellate court. So your lordship on that very date was pleased to formulate a substantial question of law, 21/4/2026, my lord. whether the impugned judgment of the learned first appellate court suffers from perversity for non-compliance of the mandatory provisions of Order 41, Rule 31 of the CPC, of the CPC. Now, my lord, your lordships, this substantial question of law goes to hit about why the learned first appellate court did not frame points for determination, as well as if there is no points for determination framed, then why the matter was not discussed issue-wise. So for that purpose, my lord, I would like to take your lordship to first, because it is a matter to be remanded, but then even I will apprise your lordship that what is the judgment passed by the first appellate court.
Mm.
And that your
No,
lordship will
no. Yes, Mr. Dubey, what is your stand on this point?
Lord, so far this is concerned, Lord, my submission would be that the 41, who it requires, there is a substantial compliance of this provision. And I'll rely upon the apex court judgment on that.
Mhm.
So issue may not be, the issue may not be decided issue-wise, but if there are materials to show that the appellate court has taken into consideration these aspects of the matter, then that would need to be a substantial compliance. Even the recent Supreme Court judgment is there.
No, that is there, but whether the first appellate court has discussed in the appeal
Yes.
the issue
It has
issues.
discussed, it has discussed. If your lordship would kindly take the first appellate order, but I can straight away not demonstrate to your lordship.
Okay.
My lord, so I would like your lordship to, before taking your lordship to page number 8 to 13, which is the first appellate court judgment.
Mm.
My lord, I would like to submit before your lordship a brief fact of the case, a brief fact of the case,
Mm.
a brief fact of the case. My lord, there was a person who was named as Faridullah.
Mm.
Faridullah, my lord, was the owner and title holder of 16 bigha 3 katta, 19 lecha of land.
Mm.
Out of that, my lord, he sold 2 bigha 2 katta 2 lecha of land to one Maulvi Mehruddin. And that sale was, my lord, in the year 1961
Mm.
by registered sale deed number 5173. 5173. Now, my lord, out of that, Mehruddin, who became the owner of that plot of land, he sold a plot of land measuring 2 bigha to one bakul, 2 bigha to the present, respondent, my lord. Respondent.
Mm.
Now, that Muhammad Mehruddin and Faridullah were in relation to each other. Faridullah sold 1 bigha land to Yusuf Ali because they have purchased the land from different purchasers. I have purchased the land from the vendors, vendi, my lord. So, my lord, this Faridullah sold 1 bigha of land in the year 1961 itself to one Yusuf Ali. And Yusuf Ali sold it to Muhammad Ali Barbhuya. And Muhammad Ali Barbhuya, after the demise of his father, had inherited the rest of the property, and that he sold to one Nurul Islam Barbhuya. So, the 16 bigha of land was there, my lord, in the name of Faridullah. Out of that, there were various sales. And they are the purchaser of one of the vendi. I am the purchaser of another vendi. That I have already narrated in my plaint, my lord. Now, 6 number of issues were framed by the learned trial court. That your lordship will be pleased to see the 6 number of issues as page number 9 of the memo of appeal, my lord.
Page number?
Page number 9, my lord. 9 of my memo of appeal, my lord.
Yes.
My lord, the 6 issues are
Yes.
whether the suit is bad for non-joinder of necessary parties, whether the decree passed in title suit number 350/95 is illegal, void, and not binding upon the plaintiff, whether the plaintiff has been illegality dispossessed from the suit land in execution of the decree passed in TS number 350. This issue is the crux of the matter, because while executing the decree passed in title suit number 350, my lord, I was evicted from my plot of land. Then whether the plaintiff has right, title and interest over the shoot land, and whether the plaintiff is entitled to get decree as prayed for, and to what other relief. Now, your lordship, this is the contents of the judgment which was passed by the appellate court in title appeal number 2/2014. Now I will take your lordship to from paragraph number 6 at page number 10.
Mm.
Paragraph number 5 at page number 10, my lord.
Mhm.
At the end, the learned trial court, on conclusion of evidence of the parties, proceeded to hear the argument before passing the judgment dated 25/11/2013, dismissing title suit number 271/04 of the appellant primarily on the ground that the sale deed of the appellant as well as her vendor were hit by the doctrine of lis pendens as contained under section 52 of the Transfer of Property Act. The suit filed by her husband was also dismissed on the same ground by a separate judgment delivered on the same day, for which separate appeal is being preferred. Being highly aggrieved and dissatisfied with the judgment and decree dated 25/11/2013, passed by the learned trial court in title suit number 271/04, the appellant preferred this appeal, challenging the said judgment and decree dated 25/11/2013 on the following amongst other the grounds as stated in the memo of appeal. I have heard learned counsel for the appellant as well as the respondent and gone through the record without with impugned judgment and decree. The main point for bona fide, the main point for bone of contention between the parties to this appeal, that the suit the main point for bone of contention between the parties to this appeal, that the suit filed by the appellant being a declaratory suit, simpliciter, with the relief of recovery of possession and not for partition, and as such, the suit ought not to have been dismissed on the ground of non-joinder of pro forma defendants against whom the suit is said to have dismissed for want of steps. Further, it is stated that learned trial court had misread the facts and evidence on record and thereby came to erroneous conclusion that the sale deeds of the appellant, plaintiff, and her vendor were hit by the doctrine of lis pendens as provided under section 52 of Transfer of Property Act, whereas the vendor of the appellant, namely Mrs. Runuma Kalita, purchased the land in question from one Noor Islam Borbhuya on 7/2/1995, and the suit being TS number 350/95 was filed by the present respondent only on 3/11/1995. Now, my lord, here I would like to elucidate a little that Runuma Kalita is my vendor. Now, she has purchased that property, my lord, from Noor Islam Borbhuya. Now, the suit which was filed in between them, my lord, the suit which was filed in the year 2005, 250/2005, my lord, there I was not a party. I never knew about that. I never knew that there is any litigation pending wherein any property of 16 bigha is involved. I was not made party. So far the doctrine of lis pendens is concerned, is not applicable upon me. Not applicable upon me. Now, my lord, thus, para 9, thus taken into consideration the main point in this appeal for determination, let me go through the pleadings and contentions of the parties. The appellant filed the title shoot number 27104 for declaration of a right, title, and interest over the shoot land and recovery of possession with permanent injunction, and further declaration that the decree in title shoot number 350/95 was obtained by playing fraud upon the court, and as such, the same is not binding upon the appellant and her husband. My lord, I would like to just reiterate again this paragraph. Title shoot number 27105 for declaration of a right, title, and interest over the shoot land. No, my lord, it was not over the shoot land. The first appellate court has wrongly my lord, may I take water, please? My lord, shoot land of TS number 350/95 is having a different boundary, and my purchase plot of land is totally having a different boundary. But my lord, when I was by the garb of under the garb of a decree, instead of ousting or instead of executing the decree upon that plot of land, which is the shoot land, I was ousted from my plot of land, my lord. I will show to your lordship that part. So, thus taken into consideration the main point in this appeal for determination, let me go through the pleadings and contentions of the parties. The appellant filed the title shoot number 271 for declaration of her right, title, and interest over the shoot land and recovery of possession. So here I distinguish that it was not the shoot land, my lord. It was not the shoot land, because shoot land of TS 350 is contained in that shoot. Record is already there, my lord. And recovery of possession with permanent injunction, and further declaration that the decree in TS number 350/95 was obtained by playing fraud upon the court, and as such, same is not binding upon the appellant and her husband. The respondent registered the suit of the appellant by filing written statement contending inter alia that the appellant and her husband never came to possession of the shoot land. In fact, the respondent number 2 and 3 purchased an area of 1 bigha, and the respondent number 1 and her husband purchased 2 bigha by registered sale deed from Maulvi Mehruddin in the year 1978. And since that day, the purchase, my lord, here again I would like to submit, my lord, that they have purchased prior to me. According to their contention, my lord, they have purchased the shoot land prior to me. I have purchased only thereafter, but not the shoot land, the land which is a part and parcel of 16 bigha, 3 katha and 2 lecha of land, but by some different person, separate person. Now, my lord, if they are after purchase is in possession of that property, then there is no question of recovery of possession, because they are in possession. They have purchased the land and they are in possession of. So there cannot be any question of recovery of the land from me. Rather, I was ousted from my purchased plot of land. I and my husband were ousted from my place of land or purchased land. Then only I filed the suit of TS 271 by Bina Datta and TS 270, my lord, by that Deepak Datta. Next case, my lord, husband and wife. Now, my lord, paragraph number 11. It is a settled law that when the party pleaded existence of a fact to obtain a decree, must lead evidence to prove the said fact in order to get favorable decision of the court. Therefore, the appellant was duty bound to tender evidence in the above respect in order to get the decree of declaration that the decree in title shoot number 350 is illegal, void, and not binding upon her as prayed for. On perusal of the record, it appears that the vendor Noor Islam Barbhuiya executed the sale deed on 7/2/95 in favor of Srimati Runuma Palita, who was the vendor of the appellant, whereas title shoot number 350/95 was filed on 30/11/95 by the respondent. This means that title shoot number 350/95 was filed after execution of the sale deed by Noor Islam Barbhuiya. Hence, the provision of section 52 of Transfer of Property Act does not hit to the case of the vendor of the appellant.
My lord, this is the ratio held by, or the observation made by the first appellate court, Now, my lord, the suit was TS 350 was filed on 30/11/95. Very much clear it is from. And I purchased the land, I and my husband purchased the land on 7/2/95.
No, 99.
Then Nur Islam Barbania executed the sale deed on 7/2/95.
In favor of,
No, I am reading the judgment. I am not saying anything from outside. I am reading the judgment before your lordship. Here, my lord, on perusal of the record, it appears that the vendor Nur Islam Barbania executed the sale deed on 7/2/95 in favor of Srimati Runuma Kolita. And Runuma Kolita is the lady who has sold that to me, who was the vendor of the appellant, whereas title suit number 350/95 was filed on 30/11/95 by the respondents. This means that TS 350/95 was filed after execution of sale deed by Nur Islam Barbhuya. Hence, the provision under Section 52 of Transfer of Property Act does not hit to the case of the vendor of the appellant. So that part, according to the judgment itself, is clear, my lord, that I was not, though I purchased in the year 1995 on 7th of February, suit is getting filed, my lord, on 30/11/95. I ought to have been made a party into that, so as to fall within the category of lispendence.
Okay.
My lord, it is a fit case for remand, my lord. It is a fit case for remand.
Hmm.
Because the learned first appellate court has forgotten the jurisdiction exercised by him. Now further, my lord, as your lordship had already pointed out, that only issue number 1 and 4 is answered by the first appellate court. I would take something from that, my lord. However, the sale deeds of the appellant was executed during pendency of TS number 350/95. And as such, the principle of lispendent attracts to the case of the appellant. Therefore, the appellant cannot acquire right, title, and interest over the suit land on the strength of sale deed. I have never claimed, my lord, I have never claimed in my petition, as well as in the plaint, that I am claiming the shoot land as purchased by them. My shoot land is totally different, my
So
lord.
the boundary is different.
Different, my lord.
Schedule is different.
Yes.
Can you show me from the record of title suit number 271 of 2004
Yes, my lord.
and title suit number 350 of 95?
My lord, I
Both
can.
the records are available here.
Reports are.
Okay. Yes.
It was a TS arena.
Okay. Two 71. Yes, 271. 200. Whether no, this title appeal was directed against the judgment and decree dated 25th of November 2013, passed in TS number 271 of 2004, right?
Yes, my lord.
But this record is of TS number 200 of 2007.
That is also. That title suit number 350.
No.
My lord, the trial court's judgment, your lordship will be pleased to find at page number 16 to 24.
You check the record.
Okay. 300. PS3. Huh? Right. Right, 200 was. 272. It was filed in the year 2004. 270, 271 whole Bina. Old PS 27204. My lord, can we get some time to flag mark those things in the midst of oblige your lordship?
But is it that record? Trial court record?
This is the record of TS number 271, 271 and 270 also, my lord. That is,
Okay.
my lord, actually,
My lord, the old suit number was 272 of 04.
yes.
Then it was subsequently renumbered as 200 of 07.
Okay, renumbered.
Yes,
Okay,
renumbered. The
okay.
name of the party, my lord, is Deepak Datta versus Malati
Gogoi.
Gogoi, Mala
Okay.
Gogoi.
Okay.
This one. And the other one will be that Bina Datta.
Other one is available or like?
This is of Deepak Datta only. The one will be also there. my lord.
Other one is of by Bina Datta.
RSA 91. এইটো ৰেকৰ্ড নাই
এইটো আছে
তেতিয়াহ'লে
এইটো
এইটো আহিব
এটা আছে,
লাগে।
সেইটো আহিব লাগিব।
কোনটো আইটেম নম্বৰ দুটা আছে
91
নাই,
RSA
একেলগত আপুনি চিকুৱেঞ্চত দিছে এইটো।
90 আছে
RSA 90 আছে হয়
টাইটেল আপিল
91 item 10 ইয়াতে আছে with TCR
and only that record
এটা ৰেকৰ্ড তাৰ মানে অহা নাই।
আহা নাই।
কৰবাত কি কল কৰিছিল মানে
এইটো ৰেকৰ্ডটো মানে LCRB কল কৰে। ইয়াতে 350 টো লিখা আছে। Yes, 350.95.
should be called. It's not কিহৰ record. Zero TA to title appeal
PS 271.
271 has not been received, but PS 271 has not been received. আপনার আবার TA appeal আহিলে, but TS আহাই নাই, but TS cancel না। 271 for running the process, submitting report.
তো অফিস তো নাই না কিন্তু 271 to 200 হৈছে পিছত
renumber কৰা নাই।
ৰিনাম্বাৰ হৈছে।
প্ৰথমটো নাই
আজি হেৰিটো
Title appeal to 271. Okay, to call for it. You call for it. You call for it.
ইয়াতে 350 টাইটেল সুট নাম্বার 350 of 1995.
That is the old suit my lord.
That is a
Old shoot which was fought in between they, Malati Gogoi and the other person, Bhuya. Yes.
That
That is,
record was not called for.
That was not
no. ভালে হৈছে মোৰ গাও ভাল নাই আপুনি এটা সুযোগ দিলে আমি ঠিক কৰি লম এইটো।
In fact, if lordship permit, they have exhibited the title suit plain, unamended plain of 350 of 95. Only the record of the title suit pertaining to these cases must have there, and their only exhibits was Lord the plain, and that too not the unamended plain. But there was an amendment of the plain lot that has not been annexed in the evidence. Lord,
এটা show করে দিব।
what has happened, Lord, if I can give a background. 1795, Rumu Kolitam Lord purchased the plot of land of 1 bigha from Lord Noor Islampur or Bhuyan, who was a defendant in title suit 350 of 95. But they have also made them party defendants in this case. But the suit was dismissed in June 99, 350 of 96. After dismissal of the suit, but the plaintiffs or the appellants had purchased that plot of land after dismissal of the suit from Runumu Kolkata. Thereafter, Milord, appeal was filed, 35 of 99, and there was an ex parte judgment in favor of the defendant's hearing, and that was put into execution. Milord, appeal is a continuation of the suit that has been held by the apex court. So, Milord, the appellate court has also came to a finding that so far as the vendor of appellant are concerned, the case is not lis pendens qua Runumu Kolkata, but it is lis pendens qua the appellant. Because it is also settled proposition that I'll argue on that, Lord. Now, Lord, they have challenged the order passed in title appeal, saying that that judgment and decree is not binding. But the fact of the matter is this, Lord, that even that judgment and decree passed by the appellate court is not before your lordships in the title suit. So a challenge has been made without that judgment being annexed. Only the references as regards the execution, where my right title and interest has been determined by the court. Therefore,
Now the question is, if the records are not available before this court, can this court?
my lord will determine. Lord, here the question is, if one alleges that the decree was pronounced playing fraud on the court, but the burden is very heavy on the plaintiff to prove. Here is a case, my lord, no averment, no proof, not even the degree is there before your lordship, the judgment. How court can presume that it's been obtained by fraud? The burden is upon the plaintiffs, not in this case. And so far as lis pendens is concerned, my lord, I am not to make them party. One very important aspect of the matter is in title suit 350 of 95, my lord, the defendant number 1, 2, and 3 have filed their written statement in 98 that has been exhibited by the plaintiffs. In that written statement, my lord, nothing has been said that they had sold this land to Runumu Kolkata. In fact, the fraud has been played by their vendors, my lords, upon them. And in the title suit, my lord, there is no relief sought against them. And they had also not taken steps, my lords, as regard those defendants, my lords, and the suit has proceeded ex parte.
Okay, Mr. Sattar, please go through the record.
My lord.
You tell me whether all the records are available before this court.
But whatever be the record before you, the trial court, my lord, is there before your lordships. Only thing, my lord, during the proceedings, my lord, they have not produced, exhibited those records. Even from our side, my lord, no evidence was leaked.
No, Mr. Dubey, you see whether this case TS number 350 of 1995 is available before this court.
No, it's not there.
My lord, plain copy of the plain produced by them,
No,
not the amended one, my lord.
That record is not before your lordship. Say simply that.
can we, no, no.
My lord, because it was the
My
earlier proceedings.
my question is, can this court dispose of this appeal without the record being made available before this court?
My lord, no, because of the identifiability of the land which is purchased by them and the identifiability of the land which I have purchased. So that record is necessary, my lord.
But my answer is different, my lord. My answer to your lordship's query is this. If the trial court, my lord, they did not provide that. In the appellate court, they did not provide that. Can they come up now and they say that this thing should
No,
be
no,
done?
maybe. But the record may be available with the trial court.
Definitely, my lord.
This record.
Those records were not called for in this proceedings of this title suits. 350 of 95.
Maybe have you gone through the substantial question of law framed by this court?
Yes.
Here it is mentioned about the TS number 350 of
But
1995.
whether that comes within the purview of lease pendants or not, that is an issue for your lordships. Since the same
No,
has been executed.
Without can this court examine the matter without the record?
Yes, my lord. But why I am saying so, my lord? Because the plaintiffs or the appellant's vendor, they have not choose to file any appeal as regards the judgment that has been passed, that has attained finality. That judgment, in fact, which give me right title in interest is not before your lordships, was neither before the trial court, neither before the appellate court, my lord. It was burden upon the plaintiff, my lord. If you have
No,
to
no,
sustain,
there is no dispute about it.
my lord.
My question is, without the record of TS number 350 of 1995, can this court decide this second appeal?
But it has to, because the first appellate
How?
court and
How?
but otherwise, my lord.
His
your lordship
argument
would
is
amount
that
to going into
the schedule of this title suit and the schedule of this
not that
271 is different.
Lord, there is no question of schedule because they have not claimed independent right. What has happened is, my lord, the Noor Islam Bhuiya.
No,
May I
can
indicate to you?
no, even then,
My lord.
can this court appreciate your argument without the record?
Yes, my lord, because the
How, on what basis?
because of the lease pendants, my lord. If your
Least
lordship
absurd
want-
submission, absurd submission. Sit down, please. Mr. Sutter, please go through the record. You tell me which record is to be called for
I will go through well.
after some time.
Number 14. Order maker.
Yes, it's happening. It will cause a-
May I please, your lordship?
Yes.
My lord, before going to the main case, I want to draw your lordship's kind attention to certain provisions of CPC and Contract Act. Lordship may kindly see Order 7, Rule 11D. Order 7, Rule 11D. It says that where the suit appears from the statement in the plain to be barred by any law should be rejected. Here in the plain, in Schedule A, it appears that the suit land is 2 katha, 5 lesa out of 7 biga, 4 katha, 7 lesa. Now, this 2 katha, 5 lesa land, how he got? That is not described in the Bainanama. In Bainanama, for a moment, my lord, I draw your lordship guidance on kindly see the Bainanama.
Page number?
Bainanama, it is, my lord, exhibited. It is exhibited. Kindly see page 14 of the memo of second appeal. That is page 14, bottom. Exhibit 1 is the registered Bainanama, page 14. Exhibit 2 is the paper giving possession to the plaintiff by defendant. Now, in registered Bainanama, it is said that মোৰ নিজ নামীয় হক সত্য দখলীয় অন্য কাৰোৰে ওচৰত দায়বদ্ধতা নথকা সম্পূৰ্ণ মুক্ত নিম্ন তফচিল বৰ্ণিত 2 কাঠা মাটি 2 কাঠা 5 লেচা মাটি সৰ্বোচ্চ মূল্য ইমান টকা 2 কাঠা 5 লেচা মাটি so 2 কাঠা 5 লেচা land he says that it is in my name in my possession and free from all encumbrances. I have made this agreement with the respondent plaintiff. Now, whether he is the owner of 2 kata 5 lesa of land or not.
Mr. Mahmood,
My lord,
where is that Bainanama page number?
Bainanama, it is exhibited as exhibit 1, my lord.
No,
The
maybe,
LCR.
whether that Bainanama is part of this memo of appeal?
No, that is not with judgment we have annexed and judgment is, it is mentioned exhibit 1 is the registered Bainanama. So it is in the LCR, my lord.
Okay. C1.
Yes, sir. So, it took PDF. Okay. Page उल्टा पुल्टा कुछ है। Page बिलक उल्टा पुल्टा कुछ है। Page बिलक मेरे मार।
It was exhibited as exhibit
1.
1.
Here, my lord, বায়ানাকৃত মাটির তফসিল নগাঁও জিলাৰ নিজ চহৰ মৌজাৰ ডিমৰুগুৰু কেঁচামতৰ 62 নম্বৰ মেদি পট্টাৰ 316-356-360 নম্বৰ দাগৰ পৰা 2 কাঠা 5 লেচা মাটি বায়নাও মাত্ৰ যাৰ চৌহদি so my lord 62 is the Medi Patta number. My lord has seen it is a Bainanama schedule of the Bainanama's land.
Exhibit 1, yes.
Now, Patta number is says 62. And there are 3 dag numbers 316, 356, 360. Now, my lord, I have given the copy of the Patta. 62 Patta. Kindly see, my lord, this is the Patta. Patta number 62, dag
No,
number 316.
whether it was exhibited before the trial court? This patta.
It is exhibited as exhibit co. That is our document.
Exhibit?
Is the exhibit co. Certificate copy the Jamabandi of Mehdi Patta number 62.
Exhibit co.
Exhibit co.
Yes.
Exhibit co is the revenue receipts. Now, Lordship kindly see 62 number Patta Lordship has seen.
Mm.
Just paper I have just given now.
Mm.
So, dag number is rightly written 316, 356, 360. Now, where is 2 kata 5 lesa land in the name of this Nasir Khan. Where is the land of Nasir Khan in this patra or within these three dags? Land measuring 2 kata 5 lesa. I do not say here. If my learned friend has any document, he may show. So if Nasir Khan has no land measuring 2 kata 5 lesa, how he can execute the agreement? How he can execute the agreement in respect of the land which he does not own? Now question is this, if the agreement is done, that is void. In that case,
No, Mr. Mahmood, you say whether any substantial question of law was framed on this point? Because we have to confine ourselves only to the substantial question of law. We cannot go beyond the same.
that is one aspect of process. There is
Mhm.
also some, my lord, in the substitution question of law, it is any other substitution question of law may be formulated at the time of hearing.
Mm,
Here, substitution question of law, Lordship would say,
mm.
whether the first appellate court committed grave errors of law and facts in not discussing and deciding all issues framed by the learned trial court. So that is not so much important, but it was framed. Whether the defendant appellant had the legal right to execute a registered agreement for sale in respect of the land measuring 2 kata 5 lesa covered by dag number 316-356-360 of Patta number 62 of Dimuru Guri Kisan Mauja Nish Shahar, district Nagaon, Assam, when there are many other co-pattadars, owners in record of right, Jabandi without making them as parties. Whether the appellant defendant who executed the alleged agreement with the plaintiff, the respondent can be asked to register the sale deed in favor of the respondent plaintiff when the land does not retain absolutely only in his name and without making the other legal heirs of Abdul Kader. Abdul Kader is the son of Nasir Khan as parties and also without determining his individual shares over the suit land. So section 29 of the Contract Act. Here, my lord, this Nasir Khan is not the owner of 2 kata 5 lesa of land of Patta number 62, dag number 316, 356, 360. So in year, an agreement cannot be executed. And if it is executed, that same is void. Secondly, the respondent plaintiff is entitled for money. And that order was passed by Learned Munshif. Learned Munshif said that, trial court said that he is entitled to get the money which he has paid. But the first appellate court has reversed the judgment. But first appellate court never tried to examine whether the executant, Nasir Khan, had the right to make an agreement in respect of the lands to which he does not own. My lord, I have, perhaps I could make your lordship understand that this is the very important crucial point. That's why, my lord, at the very beginning I said this point of law, Order 7, Rule 11D says that where the suits appears from the statement in the plain to be barred by any law should be rejected. So it is rejected because he is not the owner of 2 kata 5 lesa land.
Whether you have filed any such application before the trial court at the time of trial?
trial court discussed many things, but it was
So
only,
this is entirely a new plea. Can we entertain it at the time of second appeal? Here, at the time of hearing of second appeal?
one thing, Lordship, I am drawing your Lordship attention. No court can pass any order which is impossible to carry out.
Hmm.
That is the settled principle of law.
Hmm.
Suppose your Lordship, there is an injunction petition may be granted against the person, against which it is possible to carry out.
Hmm.
But no injunction can be
No,
granted.
Mr. Mahmood, the question is, having not raised any such issue before the court below, can
I
you
have
directly
not
raise
seen.
this issue before this court?
But my lord, my prayer is this: if your Lordship suppose gives that the appeal is dismissed, then 2 kata 5 lesser land he will get. Now where he will get the land? The decree is impossible to execute. So this court, this High Court Court of Recordment, High Court is the court of record. So when we say that 2 kata 5 lesser land he has not, but he has made agreement. Suppose if I made an agreement regarding this Latashil field that I have sold to Mr. B. I am A, but I have no ownership right over Latashil field. Then decree is void. Agreement is void. But I will be liable for punishment because I have done something which I do not have the right to do. So that Lordship, that is the order 7 rule 11 says that barred by any law, my lord, very simple meaning should be. We should not go into complex meaning. Barred by law means I have no land but I have executed. Here, the plaintiff schedule A, it appears that the suit land is 2 kata 5 lesser out of 7 biga 4 kata 7 lesser. Now, out of 7 biga 4 kata 7 lesser, here is no mention that this 7 biga 4 kata 7 lesser land are my father's. Now, Lordship would kindly see here, with document I have given, kindly see third page. Well, this third page, which I have given now, third page, pagination is not done. Here, Nozukha is the brother of?
No, Mr. Mahmood, whether this document was exhibited or not,
It is exhibited as a certified copy of Damabandi.
certified copy.
It is written one.
Exhibited as exhibit?
Exhibit A, exhibit co.
Exhibit co.
Yes. So here in third page, can you see?
Okay. C1.
Third page of the, just I have given the paper. Nozukha, son of Abdul Qadir. Nozukha is my brother. That means he is the brother of the present appellant. Now then Nasir Khan, I am Nasir Khan. And I am Nasir Khan means Nasir Khan who executed Najik Khan, Pita Abdul Qadir, Kazim Khan, Pita Abdul Qadir, Abdul Khan, Pita Abdul Qadir, Musammad Firoza Begum, Pita Abdul Qadir. So many persons are the owner of this plot of land. Now kindly see first page. Here, total land is 2 biga 4 kata 11 lesser. 2 biga 4 kata 11 lesser. But out of this land, my lord, so many lands are sold to so many persons. Kindly see second page. Kindly see second page top. তারিখৰ হুকুম মতে 356 নম্বৰ দাগে 1 কঠা 10 লাখ মাটিৰ খৰিদা সূত্ৰে আব্দুল কাদিৰৰ লগত সুলতান বেপাৰী. So this 2 biga 4 kata 11 lesser is not there because 1 kata 10 lesser land has been sold to Sultan Bepari.
Hmm.
Then Lordship would say 316 নম্বর দাগে 1 কাঠা মাটির শ্রী আব্দুল কাদরের লগত খরিদা সূত্রে নেসের আহমদ নামজারি করা হয়। Lordship has seen?
Hmm.
So land is gradually decreasing. Earlier there was 2 biga 4 kata 11 lesa. Now he is selling one after another. 1 kata 10 lesa to Sultan Bepari, then 1 kata to Nasir Ahmad, then 1 kata 10 lesa to Nasir Hussain, 1 kata 10 lesa Nasir Hussain. But this is not this Nasir Hussain. Here Nasir Khan. So then Lordship would say bottom 1 kata 10 lesa mati Nasir Hussain নামে নামজারি শামিল করা হয়। দেন 316 নম্বর দাগর 1 বিঘা 9 লেসা মাটি জয়জান নেসার নামত জয়জান নেসা স্থলত কুদ্দুস আলী নামে নামজারি করা হয়। দেন 316 নম্বর দাগর 1 কঠা 5 লেসা মাটি কুদ্দুস আলীর লগত সুলতান ব্যাপারীর নামে নামজারি হয়ে পত্র শামিল করা থাকে। দেন দক্ষিণা সূত্রে 316 নম্বর দাগর 1 কাঠা 5 লেসা কুদ্দুসের লগত আব্দুল খালেকের নামে নামজারি হয়ে পত্র শামিল করা হয়। দেন third page, it is 4th page. Here খালেকর নামত 1 কাঠা মাটি দেওয়া হয়। দেন কুদ্দুস আলীর নামত 1 কাঠা। দেন 1 কঠা কার্তিক মান্তার নামত নামজারি শামিল করে খরিদ দখল সূত্রে। দেন 316 নম্বর দাগর লিয়াকত আলীর নামত নামজারি হয়। In this way, Lordship, this is a very big voluminous Jamabandi. If your Lordship kindly calculate this, then almost all the lands have been sold. Then where is the land of Nasir Khan? But Nasir Khan executed the agreement. Then I am coming to let Lordship attention. Other point, now Lordship may kindly. Then order 14, rule 2, kindly say. CPC. Order 14, rule 2. I am not all issues judgment that I am not. To some extent, this is discussed, though in each issues that is not discussed, but those have covered. So I am not so much on this point. Then order 41, rule 4 gives other defendants the right of reversal of whole decree where it proceeds on ground common to all, which is applicable in the present appeal. But here I admit that the other defendants, that means the other brothers of Nasir Khan, have not filed a case till today. Then the remedy lies to him, to the purchaser, as per law, is that he will purchase the land of Nasir Khan's share. Then he will file a partition suit to get his share land. Partition suit he will file. Then here my learned friend's client will file partition suit. As the agreement was signed in respect of 2 kata 5 lesa of land, but there is no partition that Nasir Khan has 2 kata 5 lesa of land, so he will file a partition suit making all of them as parties, and he will get the share of Nasir Khan, but it is not done. Then without partition, where is the land of Nasir Khan? Definitely, as on today, he has not filed any partition suit. It is the law. I will show you. That's after some time I am showing the Honorable Court. Then, my lord, may I kindly see section 52 of Transfer of Property Act. TP Act of this. Here, Transfer of Property Act clearly states that such transferee cannot claim the benefits of section 53. Section 53A is not available to this transferee. That is the respondents. That's what it is. Lordship, I am reading. During the pendency in a court, in any court having authority, government or established beyond such limits by the central government or any suit or proceedings which is not collusive, in which any right or to immovable property is directly and specifically in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceedings so as to affect the right of any other party thereto under any decree or order which may be made therein except under the authority of the court and on such terms as it may impose. Now, only under the authority of the court. But authority of the court, how court may ask him that you execute 2 kata 5 lesser land to him, you execute it because he has no land. Now question is to send him to jail or to return the money with interest. Now, Lordship may kindly say, section 44 of Transfer of Property Act, transfer by one co-owner may be entered by way of partition. My lord, there is a clear version of text of the wisdom of the parliament that transfer by co-owner may be entered by way of partition. What is the partition? Neither I have any partition case I filed, nor the other party has filed. How he will ascertain how much land I do have? How? Without partition, how he can say 2 kata 5 lesser land I will get? Is he made any partition suit? And partition suit said that yes, he has 2 kata 5 lesser land. Or I have not done. I admit I have committed some mistake. But for that mistake, any order cannot be passed which is impossible to carry out. Lordship now kindly see section 2 of Contract Act. Two and definition. Section 2I. Definition. Here, an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. So it is a voidable contract. Section 2I of Indian Contract Act says that it is only executable if even he has got land. Here, my lord, I am trying to convince your lordship that here, if even this Nasir Khan has 2 kata 5 lesser of land, but there is no partition, at that time with option of other legal heirs, he can do this. But here is not that case. It is then Lordship may kindly see page, section 29 of contract there. 29. Agreements, the meaning of which is not certain or capable of being made certain are void. There is no certainty. There is no certainty what land I do have.
Mr. Mahmood,
Well-
please confine your discussion only in respect of the substantial question of law framed
Yes,
by
my
this court.
No, because my lord,
We cannot reopen the entire matter here.
my lord, what, my lord? I remember one judgment subject to correction that when a court will pass any order,
Mm,
it will keep in mind all the laws prevailing within India.
mm,
Because every law has some bearings.
mm,
So if I pass an order which is against any other law
mm,
enacted by the parliament,
mm.
so that is the, I very forcefully I can say that is the judgment also.
Mm.
And also it is in textbook that whenever a court will pass any order, it will keep in mind that all the laws
Mm,
prevailing within India which are enforceable as of today.
mm.
So my lord, these are the sources through which we get our wisdom to be reflected in our judgment.
Mm.
Let on
Okay. We'll resume after 5 minutes.
my lord. Keeping your lordship's kind view, I am giving one judgment of the Honorable Supreme Court.
Mr. Sutter, Mr. Mahmood, 1 minute. Mm. Come this side. Come this side.
My lord, we have already searched the record.
Hmm.
These are the records which are not available right now before your lordship. So we have prepared a list.
No, that's all right. But the question is, can this court decide this appeal without those records?
No, my lord, because, no, my
Okay.
lord. So can I give it to the court master, my lord?
Yes, you have second.
Perhaps, yes, I'll check. No, perhaps that I could not explain to your lordship, not what was my submission, but I did not see, so far as the other appeal is concerned, Lord. No, there are two appeals before your lordships. In respect of one, the entire record has come. In respect of other, it has not come. So
That's
that has to be called for.
Okay.
So far as other thing was, I was making a mention before the lordships that the records are pertaining to earlier suits. No, it's not that your lordship cannot look into it. What has happened, only part of those records were exhibited. In fact, they exhibited only part, that to unamended plaint and written statement.
No, that's all right.
No,
Therefore,
we
the
cannot
original
accept
record is necessary.
So, my lord, if there was a provision for calling of record also, my lord, neither of the parties has my lord, explored that possibility. But for substantive justice, your lordship can call for. It's not that what was I was submitting was that this was not part. And even without that, that can be decided, my lord. My submission was in that respect, my lord, not the original record of this. And if your lordship is, my lord, that would also support my case. It's not a matter of supporting either. To make it clarify, it's better if your lordships call for that.
Okay. You give the list to the court master.
Obliged.
We'll call it.
Obliged.
We'll list the matter after 2 weeks then. Or after vacation.
My lord, let it be after vacation because the records shall have to come, my lord.
Okay.
After
Okay.
vacation.
After vacation.
Obliged.
We'll fix it.
But my lord, may kindly indicate the 4 things plus that would suffice. Not in the record also, or in the order.
Okay, I will indicate it. Take a date from him
Yes.
after vacation.
And my lord is keeping it as a part of it.
Yes, part. Yes, Mr. Mahmood.
I have given the copy of the judgment, my lord.
Hmm.
It is 2024 INSC 676. Here, my lord, may kindly see, I am minimizing the time of the honorable court, my lord.
Hmm.
Para 12, kindly see. On the pleadings and submissions of the parties, moot question, which has been arisen before us in the appeal is whether Brijmohan, son of late Sitaram,
Hmm.
Alan was competent to transfer the entire suit property by way of sale deed dated 19/5/2006 in favor of defendant appellant S.K. Gulam Lalchan. Now kindly see para 23. A faint effort was opposite party matter. Faint effort was made to contend that the plaintiff respondent Nandulal had not asked for any relief of cancellation of the sale deed by which the property was purchased by the defendant appellant S.K. Gulam Lalchan, and therefore is not entitled to any relief in this suit. The argument has been noted only to be rejected for the simple reason that Section 31 of the Specific Relief Act 1963 uses the word may for getting declared the instrument as void, which is not imperative in every case, more particularly when the person is not a party to such an instrument. The suit property, these are very important, my lord. The suit property which is undivided is left with the co-owners to proceed in accordance with law to get their shares determined and demarcated before making a transfer. So that is determined demarcated before making a transfer. The point for determination formulated in paragraph 12 above is accordingly answered, and it is held that Brijmohan alone was not competent to transfer the entire property without getting his share determined and demarcated so as to bind the other co-owners. Accordingly, the defendant appellant Sheikh Gulam Lalchan has rightly been restrained by the decree of injunction in acting in derogation of the propriety rights of the co-owners until then unless the partition takes place. Now, Lordship would see this. Then, my lord,
Mr. Mahmood, you say, is it your case that Nasir Khan has sold the entire plot of, no, entered into agreement for selling the entire plot of land?
actually, my lord,
Hmm?
entire land or lesser land.
Hmm.
Question is this: Nasir Khan had no 2.5 lesser land.
No, maybe he is the co-owner. You see Section
He
44
is
of
the
the
co-owner. Definitely, he is a
Transfer of
co-owner,
Property Act.
my lord. He is a co-owner,
Hmm.
but he cannot transfer his title to other persons without being partitioned and demarcation. This is the maxim of this judgment, my lord.
It is. So he is entitled to share his part of the land.
His part of the land,
Hmm.
but thereafter, yes, my lord, that is true.
Hmm.
His part of land he can transfer.
Hmm.
But for that, the purchasers have to file a partition suit.
Purchaser?
Purchaser has to file a partition suit.
How?
Yes, he will file that I have purchased this plot of land. This is the share of Nasir Khan.
Hmm.
So thereafter, then only the sale deed would be valid. Okay, this is the I am just reading that, my lord. Both side. First, Nasir Khan would have filed the partition suit, get his land portion demarcated, then he could have executed the sale deed, agreement for sale deed.
Is it the requirement of section 44 of the Transfer Property Act?
Yes, that is the requirement.
You see,
Section
read it
44
again.
of Transfer of Property Act. Yes, section 44. Where one or two or more co-owners of immovable property legally competent in that behalf transfer his share of such property or any interest therein, the transferee acquires as to such share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to the condition and liabilities affecting at the date of transfer the share or interest so transferred. So, my lord, on the day when he executed the agreement, and on that day, what was his share? What was his share? That is not ascertained. Now, after reading that, kindly see my judgment which I have given. The suit property, which is para 24, my lord. The suit property which is undivided is left with the co-owners to proceed in accordance with law to get their shares determined and demarcated before making a transfer. Making a transfer. Before transfer, that should be partitioned or demarcated. That should determine. It is very clear word, my lord. To law to get their share determined and demarcated before making a transfer. So here is not this case, my lord. Here no partition was there, no demarcation was there. Simply, I am the owner of 2 kind of fabulous land. I have made an agreement that in due course of time I will get the sale deed registered. So nothing is, there was no demarcation, no partition, no definite share what he has. He wrote 2 kind of fabulous. He could write 10 bigas also. So that is an ambiguous term, my lord. Then the point for determination formulated in para 12 above is 12. First I have read, my lord, 12. Para 12. On the pleading, para 12, kindly see for a moment. On the pleadings and submissions of the parties, the most question which has arisen before us is the appeal is Brisbane, son of Sitaram alone, was competent to transfer the entire suit property by way of sale deed, that is so and so, in favor of defendant appellant Sheikh Ghulam Lal Chand. So this is answered in para 25. The point for determination formulated in paragraph 12 above is accordingly answered, and it is held that Brisbane alone was not competent to transfer the entire property without getting his share determined. Here, entire, let the word entire be forgotten for a moment. His property without, here let us read from without getting his share determined and demarcated as to bind the other co-owners. According to the defendant appearance, Sheikh Ghulam Lal Chand has rightly been restrained by the decree of injunction enacting in derogation of the property rights of the co-owners until unless the partition takes place. Until unless partition takes place. So Ghulam Chand Zohar purchased, but he was restrained by of injunction by courts below. Honorable Supreme Court has set aside that. Rightly he has been restrained until the partition takes place. So now partition may be from 2 sides. Well, first I would have filed a partition suit. He can also file a partition suit, even after executing the deed.
No, Mr. Mahmood, you say here sale deed was executed in the present case referred by you,
Yes.
but in the appeal in question,
It was
it
not
is for
executed.
specific performance of the agreement.
Yes, yes. But principle of law is the same. Principle of
How?
law ratio is the same.
How?
Because for sell would be the second part. First was the agreement.
Hmm.
The agreement is the condition precedent of sell deed.
Hmm.
So in agreement you have no land, you have no definite portion of land. How you can go to that is far away. First agreement you have made, there is no specific share of you, there is no partition, no demarcation. You have made announcement that I am selling, I have executed this sell deed, execution agreement, executed this agreement to sell this. So my lord, lordship would kindly go through these judgments. Here, the other day, our High Court, my lord, our High Court, in RFA number 42, 2019,
Hmm.
I ordered it as 7/4/25, my lord. 7/4/25, it is 1 year, almost 1 year, 1 month. Here, lordship is exactly that they are the same. Here, kindly see para 44. In view of the ratio of the judgment of Honorable Supreme Court in the case of Fateh Chand versus Bal Kishan Das, AIR 1963 SC 1405, it is held that plaintiff respondent is entitled to refund rupees so and so only from the defendant appellant. Accordingly, the suit will stand decreed for the monetary amount of rupees so and so 4,50,000 only in favor of the plaintiff respondent and against the defendant appellant. In view of the aforesaid discussion, the suit of the plaintiff seeking exclusive affirmation as against the defendant is dismissed and appeal is allowed. However, in favor of the plaintiff, a money decree is passed for a sum of rupees so and so. So here, monetary relief which the landed munship has ordered, that is upheld by our High Court. Now, what is the decision? That is. Go to field of the- that is. So then, okay. 2020. That's the recent order he was talking about. All the way to the window. 2024 SCC 1.
So,
Page
how
one.
this decision in RFA 42 of 2019 will help you?
But that was also regarding an agreement was signed between the parties,
Hmm.
and the executor did not execute the sell deed.
Hmm.
The landed court below
Hmm.
asked to execute the sell deed. Court below means unless civil just senior division
Hmm.
asked to execute the sell deed. In High Court said no, the sell deed is not necessary, nor entitled for, but money what he has paid
Hmm.
should be returned.
Hmm.
So this is the substance of the case. Now,
No,
in this
that's all
regard-
right. But how this decision will help you? How it is relevant in your case?
in my case, well, same thing. We executed the sell deed,
Hmm.
and landed munship granted monetary relief.
Hmm.
First appellate court said that they execute the sell deed. So against that we have come. So our prayer would be, in terms of the judgment, the monetary relief should be provided with the landed munship.
No, is there any pair?
Hello?
Is there any pair for returning the amount? Is there any counterclaim?
In that regard, my lord, I will show your judgment of Honorable Appeals Court. If the party proves a case and though not paid for, court is entitled, court is,
Hmm.
okay, court has to provide relief, my lord.
Hmm.
Here, I am, just substantial question of law in our case, he was that. It is therefore, our prayer was that, my lord.
Hmm.
It is therefore prayer that your lordship will be pleased to admit to appeal. Call for records, issue notice to respondents, and upon hearing the parties, perusing the records, further be pleased to set aside the judgment dated 25/19 and decree dated 1/6/19 passed by learned civil judge Nogang entitled appeal number so and so and or pass. So and or pass. So the judgment was prayed for to set aside. So if the judgment is set aside, then the order of Munshi will prevail.
Hmm.
If the judgment which we have challenged in this RSA
Hmm.
is set aside, that means the Munship's order will automatically prevail.
Hmm. Is there any direction for returning the amount? in
Yes.
the month?
Learned Munship said this. Page 18 of the RSA.
Hmm.
Page 18, para 8. May I read, my lord?
Hmm.
But from the evidence tendered by the plaintiff side, whether oral or documentary in respect of the agreement for sale in question, it is safely established that defendant agreed to sell the Schedule A land to the plaintiff and received rupees 87,500,000 as advance amount from the consideration amount and thereby executed the registered deed of agreement for sale the said land in favor of the plaintiff. On the other hand, the defendant had failed to prove that the said bananama was executed fraudulently. That being the position, it is seen that the plaintiff is only entitled for recovery of the amount which he paid to the defendant at the time of execution of registered deed of agreement, Exhibit 1, and he is entitled for a decree for a specific performance of contract. Thus, the plaintiff is entitled for a part decree, and he is not entitled for a decree for a specific performance of contract,
Hmm.
but he is entitled for recovery of rupees 87,500 only from the defendant along with 6% interest per annum from the date of filing of the suit till recovery of the.
Now you come to page number 8. The plaint. What are the pairs there?
Plaint was filed by opposite party.
Hmm.
Prayer is their decree for be passed for a specific performance of contract against the defendant, directing the defendant to execute the sale deed
Hmm.
in favor of the plaintiff on receiving the balance amount of so and so.
Hmm.
If the defendant fails to execute the sale deed within the stipulated time given by the court, then the court may execute the sale deed in favor of the plaintiff by receiving the balance amount of so and so.
Hmm.
A permanent injunction, cost of the suit.
Hmm. There is no pair for alternative relief.
No, my lord, my lord, we pray for bail even a murder case. The court does not give.
Hmm.
So our prayer is indefinite. Indefinite. We may seek many things from you, but you will give us what is as per law.
No, without asking by the party, court can grant relief.
Yes, that is the judgment also. There is also judgment.
Hmm.
But let me first, lordship, satisfy your lordship. In recent 2024 SCC,
Hmm.
1, page 1,
Hmm.
para 23, my lord.
Hmm.
Merit.
Where is the copy?
I have given the citation. SCC. SCC in our High Court available. It is SCC. Here I just said, my lord, this brings us to the question as to whether a ruling of a coordinate bench binds subsequent coordinate benches. It is now a settled principle of law that the decision rendered by a coordinate bench is binding on the subsequent benches of equal or lesser strength. The aforesaid view is reinforced in the National Insurance Company Limited versus Konoy Sethi. So the two judge bench in Santosh Devi should have been well advised to refer the matter to a larger bench as it was taking a
No, no,
different view.
That is not the issue before this court now.
Issue means, my lord, that what by
That
my
RFA judgment.
RFA, yes. That
No,
may be
no,
said.
no, no. That cannot be. That cannot be.
My lord, just have a look at para 40 of the RFA judgment, my lord.
I am almost in complaint. I am very shortly, definitely will argue.
Yes.
Para 21.
They had a plaintiff failed to prove that he is willing to pay the money.
Specific relief act, lordship, para section 21. Specific relief act. Para power in a suit for a specific performance of contract, the plaintiff may also claim compensation for its breach either in addition to or in substitution of. In substitution of is what is there of such performance. If any such suit, the court decides that a specific performance ought not to be
Yeah,
granted.
you are referring to section
21
21.
of a specific relief act.
Yes.
In a suit for a specific performance of contract, the plaintiff may also claim compensation for its breach either in addition to or in substitution of. This is applicable in our case of such performance. 2, if any such suit, the court decides that a specific performance ought not to be granted, but that there is a contract between the parties which has been broken by the defendant and that the plaintiff is entitled to compensation for that breach, it shall award him such compensation accordingly. So compensation what is there. Provided that the proviso may be seen, provided that where the plaintiff has not claimed any such compensation in the plaint, the court shall, at any stage of proceeding, allow him to amend the plaint on the such terms as may be just, for including a claim for such compensation. Explanation, the circumstances that.
Mr. Mahmood,
My lord.
there is a very recent decision of Supreme Court, perhaps in the year 24, where it is stated that even this page number 8, point number E, in the PR portion of the plaint, any other relief or reliefs to which the plaintiff is entitled in law and equity may be granted to the plaintiff. So even under this head also, the court cannot grant such a power. No, so sorry, such a relief.
The court can, if the case is the case is
Unless such pair is made specifically in the plaint or in
Your
the
lordship, I am totally in
written
agreement.
statement or in the
Another judgment, lordship, I am showing you
Mm.
just now. I am showing that that if even something is not prayed for, even then court may grant the same. First, let me show that is one 2002
Mm.
2 SCC 420 para 9
2000?
2002 2 SCC.
No, this is not in
420.
your list.
My lord? No,
That judgment is not
in
there in
reference
this
I am saying only that that is not in list, but I am reading that legal proposition of Supreme Court's law. Legal proposition laid down by Supreme Court cannot be bypassed by any court, including the highest court of the state, on the ground that the attention of Supreme Court has not been drawn to a specific statutory provision.
Mm.
So here, the judgment says Lalchan, I have given. So
Mm.
that is the legal maxim of the Honorable Supreme Court, that attention though was not totally, partially not drawn, but that is binding upon courts.
Mm.
That is the maxim of this law. That is very much
Mm.
Suganthi Suresh Kumar.
Mm.
Suganthi, this is the case.
Mm.
Suganthi Suresh Kumar. Regarding if not prayed for, even court may provide relief, that I am giving, my lord. My lord, yes, I have got 2006,
Mm.
1 SCC
Mm.
479. Kindly note
That
down.
is in respect of a writ petition or special leave petition or what?
Here, my lord, I am reading the.
No, no,
Oh.
Mr. Mahmood, you say the principle being followed in the writ petition under Article 226 and in the RSA are quite different.
Here, my lord, it is under Article 141 and 142.
Under
That is power is
226,
vested
court
upon
can,
Supreme Court, not in
can
High Court.
mold the relief.
But
But,
ratio I am saying, my lord,
Mm.
court always need not wait for statute to provide relief. Constitution of India,
Mm.
Article 142, 36, inherent power of the court, power to
No, no,
mold
that
relief.
power this court does not have.
But the legal
140,
provision.
141, 142 only the Supreme Court can exercise. This
No, my
court
lord, my
cannot.
last submission is this.
Mm.
Suppose your lordship has dismissed my appeal.
Mm.
This person has no land.
Pardon?
This present appellant,
Mm.
who was the defendant in the title suit,
Mm.
has no land.
Mm.
At least they could not show that. This is very important. If I have purchased a plot of land,
Mm.
I must go to the circle office and see the record of rights,
Mm.
that whether Mr. A has a plot of land
Mm.
which he can sell.
Mm.
Let them show that Nasir Khan has 2 kata 5 less of land absolutely in his name.
Mm.
Otherwise, the same will be only a paper decree.
Mm.
So,
That
lordship,
is,
I
that is a
hope.
different aspect. Whether it is executable or non-executable, this court cannot decide. This court has to decide only the substantial question of law framed at the time of admission of this appeal.
Substantial question of law also covers that matter.
Mm.
Because, my lord, whether in absence of any finding by the learned courts below regarding the genuineness of the agreement,
Mm.
the agreement is
Genuineness
not
of the agreement is a question of fact,
fact.
right?
Fact, but when
Yes.
fraud is discovered, that is question of law. It will come.
Fraud, whether in respect of any fraud, this there is any substantial question of law?
Fraud, my lord, that is
Not there. It is not there.
what I
Then
say.
you are not entitled to argue on
In
that
order
point.
to discuss the find the word fraud,
Mm.
other surrounding elements should be taken in consideration.
Mm.
So I think, my lord, he has committed fraud.
Mr. Mahmood, you see, these questions of law, substantial question of law, were framed by this court as suggested by you. Can you show me, is there any substantial question of law on the point of fraud?
My lord, though it was I have submitted the substantial
Yes.
question of law, but
Yes.
that is now the property of the court.
Maybe.
But because court has
No,
accepted that.
yes, you showed this court that you have suggested such kind of substantial question of law.
That is accepted by the court.
Hmm.
So it is court's property now, not my property.
No, is there any issue in the substantial question of law in respect of fraud?
Actually, it is everywhere, my lord. For
Everywhere.
instance, whether the defendant appellant had the legal right
Mm,
to execute a registered agreement for sale in respect of land measuring 2 kata 5 lesa
mm,
covered by dag number so-and-so, pata number so-and-so of so-and-so,
mm,
when there are many co-pattadas.
mm.
So it is a kind of fraud. I have so many pattadas, but
No,
I
no,
allowed
no.
him.
This
So
section 44 of the TP Act,
that is there at the option.
you have shown the provision to this court.
But option I have, others have not given any option. Then 3 is also like that. Whether the appellant defendant who executed the alleged agreement with the plaintiff respondent can be asked to register sale deed in favor of respondent
Mm,
when the land does not retain absolutely on his name.
mm,
That is there.
mm.
Let them show that Nasir Khan has 2 kata 5 lesa land. Let them show. It is when they, my lord, what is the burden? Burden of proof should be discharged by the person who wants some benefit. They want the benefit of 2 kata 5 lesa. It
No,
is their burden.
Mr. Mahmood, you see, here the pair is for specific performance of the contract.
Yes.
Here the agreement is exhibited at the time of trial.
Yes, that was exhibited. Exhibited.
Is it your contention that your signature in the agreement was fraudulently taken?
Yes, in a WS to some extent, no, not fraudulently order is not there,
Uh,
but other things are there which lordship may take into consideration.
no, if it is not there, then where is the question of fraud?
But, something is there, man. Something
Where?
is there. Page 9, kindly see
Mm,
of appeal. Para 7.
mm,
The suit is bad for non-gender of necessary parties.
mm,
All other legal heirs of late Abdul Qadir, namely Kasem Khan,
mm,
Saleha Begum, Nur Jahan, and heirs of deceased Naju Khan, Najim Khan, and Abul Khan,
mm,
and also heirs of deceased daughters, namely Rejia Begum and Suraya Begum, and all other pattadas of suit patta
mm.
land are necessary parties. So, and all other pattadas, that is not necessary. But these names, who are the legal heirs
Mm.
of this Nasir Khan, they are
No, that is already settled by Supreme Court in a 3-judge bench decision in custody, in the case of custody. That in a specific performance of the agreement,
Yes.
contract, there is only 2 party.
parties too. Here is also party, 2 party.
Mm,
But I have no land, yet I have executed the agreement. And let them show, my lord. My last submission is this, madam.
mm,
My last submission is this. It is a settled position of law
mm,
that when one party wants some benefit, that here he wants that 2 kata 5 lesa land he wants to get it registered. Now burden shifts to him. Let him prove that 2 kata 5 lesa land are in the name of Nasir Khan. That is my last prayer, madam.
mm.
Otherwise, any person will make agreement regarding a plot of land, then we will say you get it executed. So it is not. So let them prove that 2 kata 5 lesa land absolutely belongs in the name of Nasir Khan. That is my answer. Because he wants the benefit, and it is his burden to prove it. My honors I have shifted.
Well, the difference, well, learned friend is related to judgments.
Mm.
One is that our High Court judgment RFA, I'll place the rest of things later on. That judgment was based on the finding that the plaintiff could not prove his financial capability to pay and that he was willing to pay complete his part of the contract.
Mm.
So under those circumstances, court ordered that you refund him the money.
Mm.
So that was that. So this fact, the facts of the case were totally different. The plaintiff was not in a position to pay the money. Therefore, whatever money he has paid was allowed to be refunded. That
No, Mr. Doctor, is there any pair
Yes.
in the plaint of that case
No.
regarding this alternate relief?
No, that's what I'm saying. That was a different case altogether.
Mm.
What happened?
Mm.
The plaintiff there, he filed the case for the specific performance, but he could not prove his financial capabilities, etc., to make the payment. So
Mm.
therefore, under those circumstances, court said refund the money.
Mm.
So it's a totally different tax. Here in this case, as the Lordship has rightly pointed out, we did not pray for refund of the money.
Mm.
We only said you perform the contract.
Mm.
And Lordship, my learned friend is been arguing, proof, possession, that this decree cannot be executed. We have already been put into possession by his own date. We are in possession of the land.
Okay.
It's only with regard to execution of the state deed that the state deed has not been executed by him.
Well, you are in possession of the land.
That I'll show that deed has been proved because there's a concurrent finding on that.
Mm.
The agreement has been proved. The sale, the possession has been proved.
Mm.
In the first appellate, the trial court gave a ruling in that favor. It's in my favor that I am in possession of the land. That has been proved. And the sale, that the agreement was executed. Exhibit 1 and 2. Because since he did not execute the sale deed, he executed a deed in my favor, giving me the possession.
Mm.
That aspect he has not challenged in the first appeal.
Mm.
That decree was partially in my favor and partially in his favor. In my favor, it was decreed that the agreement is true and the possession that a deed was executed, handing over possession of it is true. And this, the Honorable First Appellate Court also recorded this fact that he did not challenge that part of his in the appeal.
Mm.
Judgment.
So in respect of possession, there is concurrent finding of fact by both the court below.
Yes.
Okay.
And that the agreement has been duly proved, there is concurrent finding. The learned First Appellate Court has recorded that he did not challenge the part which has gone against him. Page number 30, Your Lordship will find.
30.
30.
Yes, paragraph number.
18, my lord.
Yes.
It is the pleaded case of the defendant responded in the suit that he never executed the agreement for sale. He actually denied the agreement. And nor did he receive any money in advance, as alleged in the agreement in question. Is a document manufactured by the plaintiff for making unlawful gain. Yet when the trial court hold that the defendant respondent did execute and register the agreement for sale in question in favor of the plaintiff appellant and received 87,500 from him as earnest money, and further that the defendant failed to prove his plea that the agreement for sale in question was executed fraudulently. The respondent did not raise any grievance by filing any cross-examination in the instant appeal, disputing or challenging the same finding of the learned court below in issue number 2, or for that matter did not challenge the decree passed by the trial court asking the defendant to refund 87,500 to the plaintiff. So far as that finding is concerned, that the sale deed has been properly executed because there is not a fraudulent sale deed or that the sale deed is not executed by him.
Mm.
The court came to a finding that the sale deed was executed by him, and therefore he ought to have challenged this in the first appeal. He did not challenge the first appeal. So now he cannot raise this question in the second appeal, saying that the agreement was fraudulent or agreement was wrong or something like that.
Mm.
Because that option he did not.
Mm.
Now, Lordship will therefore see, my lord, that the learned trial court thereafter went on to decide almost all the issues. The first substantial question of law.
Mm.
As per Murugendra, whether substantial question compliance is required.
Mm.
In this particular case, I have made a small note for the Lordship. It's a gist of my lord both the courts have discussed on the various issues. The learned First Appellate Court, I have just made a small summary. That's all.
Mr. Datta, furnish a copy to him also.
Yes. The learned trial court, my lord,
Mm.
framed as many as 5 issues.
Mm.
And the appellate court discussed all the issues for the questions that can arise in this question, in this case. The first issue, of course, the trial court gave a finding on specific to this particular issue, but the trial court, first appellate court clubbed these issues together and raised the point for determination. Formed the point of determination, and while deciding that point, it decided all the issues one by one. What can be the consequences? What are the factors or what are the questions that are involved in this case? Now, whether the suit is maintainable in the present form, the trial court held that the defendant side failed to produce any evidence why the suit is not maintainable. The court has not found anything on record which makes the suit not maintainable. So therefore, the suit was held to be maintainable in my favor. Then whether the defendant made contract to sell the land mentioned in the Schedule A and executed deed or agreement bearing sale deed number so and so. Now the trial court in page 16. Now you will find the trial court in page 16. I have just made a small summary here. The registered deed is exhibited as Exhibit 1. PW4 Azizur Rahman admitted that he has signed the document as witnesses, and Nasir Khan has put his signature in front of him. In his cross, he states that both Nasir Khan and Nurul Amin had come to take him. The deed was written between 11:30 and 12 p.m. PW5 Yaqub Ali states that the deed was written by him. He read out the deed. Nasir Khan had signed before him. He put a signature as a deed writer, Exhibit 1.1 and 1.5. The transaction was, he could not say about the exact amount, but he said transaction was 78,000 or 87,000, but was not made before him. Then, my lord, one Vivek, they identified Nasir Khan in the same date. PW6 Vivek, they stated that he was the witness to the Exhibit 1. The deed writer read the exhibit after writing. Then Nasir Khan put his signature. Then thereafter, going through the evidence of PW's and the documents, it appeared that the Exhibit 1 was executed and registered within the plaintiff and the defendant. So this court comes to a finding the trial court. It appears that the plaintiff agreed to execute the same day after obtaining the requisite permission and received 87,500 as an advance out of consideration of 1,500,000. Plaintiff made repeated requests to execute the same day, and then this is important, the defendant on 31/12/2025 by exhibit number 2, exhibit 2 in writing, delivered possession to the plaintiff. PW 2 and 3 testified that the exhibit 2 was written in their presence and they put their signatures exhibit 2 and 2/3 respectively. Defendant's case, on the other hand, was that he had no authority or right to sell the land. Abdul Qadir was one of the original pattadar of the suit land. He died in 1982, leaving his wife, 5 sons, and 4 daughters, and they inherited as per Mohammedan law and used to possess the land jointly. He exhibited Jamabandi. This of course, in mind, I have just made a short description, but these are what the findings of court gave. He exhibited Jamabandi number of Mayadi Patta number 62, like Khaw in the revenue receipts exhibit Khaw. Patta number 62 comprised of 3 dags, 350, 60, 56, and 60. It was original name of Abdul Qadir and his shares jointly and other inherited in his mining. Plaintiff number 1 in his cross-examination stated that he does not know the total land in the patta. He did not ask for the Tarani about the patta and the land in the patta. He did not know from whom Nasir Khan got the land and how much he got the land. Thus, he did not verify and inquire about the suit land. That part it goes against me, but the trial court ruled against me. As the suit land is not specifically muted in the name of the defendant, it would not be appropriate for this court to grant decree for specific relief in contract in respect of the suit property. Defendant agreed to sell the suited land and received 87,500 as advance. Amount and executed a deed. Failed to prove that the biennial was executed fraudulently. Plaintiff is only entitled to recover the amount which was paid by the defendant. So the trial court tells that since I did not make inquiries and all, therefore I cannot get a victory for specific documents, only I am entitled to refund. Now, Lordship sees the finding of the appellate court. Appellate court discussed various factors. That's why I made a small summary. I can go to the judgment also. This things will be revealed. On the issue of execution, the agreement for sale, the findings of the trial court have not been challenged by the defendant by filing any cross-examination. We just read at page 31. It was pleaded by the counsel to the respondents that the agreement for sale was signed by the defendant only, and it contained no promise from the plaintiff, and hence the agreement is not enforceable. One of the ground raised here in this case was, my lord, that agreement was signed by only him. I did not sign. So therefore, only one party has signed the agreement. And the honorable court had decided this issue, the appellate court had decided the issue, that even in one-sided agreement, an agreement signed by one of the party is a valid agreement, and he relied upon a Supreme Court judgment. I'll place that also. Court discussed the judgment of Alka Bose, that is the judgment. Alka Bose versus Paramatma, Devi, AI 2009, SC 1527, and held that an agreement for sale signed by the vendor alone and delivered to the purchaser and accepted by the purchaser are also be considered to be a valid contract. I rely upon that judgment. The court considered the statement of witnesses and from the deed extracted the covenant that the 2 katta 5 lecha of land is owned and possessed land. The agreement was for lawful consideration. The plaintiff was obliged to pay full consideration, and the defendant was obliged to execute the sale deed. The agreement one having exhibit one agreement having said that the land is his own land, possessed by him, his siblings were not necessary parties. So court also went to the question whether the other persons are necessary parties. Further, the father of the defendant had 7 bigha, 4 katta, and 7 lechas of land. My land is only 2 katta, 5 lecha. Out of the 7 bigha, 4 katta, 7 lechas of land. If Kasturi versus Aya Perumal and others so-and-so, reporting so-and-so, Honorable SC had that suit for specific performance that your lordship was referring to the 3-bench judgment. Only the contracting parties are necessary parties. Under section 44 of the TP Act, when there are several co-owners, the transferation steps will choose the transfer. Further, there is no contract of the joint family under Mohammedan law, and the concept of co-owner has the right, and a co-owner has the right to sell his undivided share. By Exhibit 2, the defendant admitted that he failed to obtain permission and was putting the plaintiff in possession and would execute the registered sale deed after obtaining permission. Here, the trial court decided the various facets. One party agreement was signed by one of the parties only. Then, in a under Mohammedan law, whether he could have transferred his share. Under section 44, what is the provision? Then, my lord, that who are the contracting parties, and in a suit for specific performance, only the contracting parties are necessary parties, others are not. Now, here is a case, my lord. My learned friend's case is that he executed the agreement. Now, what he's trying to say is that there are other legal heirs. It is not a case where other legal heirs are challenging the agreement, saying that no, you could not have sold our land. That is not the case of any other third party. That this suit is bad because, or this agreement is bad because Nasir Khan, without intimating us or without our knowledge, sold our share of land. No one is claiming that. My learned friend is himself claiming after having executed the agreement, now he doesn't want to part with the land. He is now claiming, no, I cannot execute the sale deed because my brothers are there, my sisters are there. That's his case. He says that no, I cannot execute this agreement because this land doesn't entirely belong to me. So therefore, under those circumstances, court found that other parties, since other parties also not there, and I had filed the suit for specific performance against him. And as for Kasturi, I was required to make him a party, and he is a necessary party. Other I did not make any party. As I've said, Your Lordship, for the most important points that the sale deed was executed, and thereafter, since he could not, agreement was executed. Since he could not execute the sale deed, he put me into also possession by Exhibit 2. Those 2 documents and the manner in which those documents were executed, by bringing in the witness who signed, etc., who wrote, etc., have all been proved. So the documents was duly proved that this agreement was executed, this possession deed was executed. That he is not challenged. His only challenge is that I cannot sell the land because there are other sharers in the land. Now, I have placed the judgment the other day on Mohammedan law. That I think is the place there. That is big. 2023 Supreme Gauhati, 1993.
Yes.
Lordship, kindly look at para 18, my lord.
Yes.
In respect of substantial question of law number 2, it appears to the provisions of section 14 and the principles of nominal law written by so and so that on the death of nominal, his all estate devolves on his heir at the moment of his heirs at the moment of his death, and his heirs succeed to the estate as tenants in common in specific shares. Therefore, court does not find that there is any bar in claiming partition with respect to the properties held in common without seeking partition of all the properties. Be that as it may, it appears that the proforma response number 2 and 3 and their mothers who examined their so respectively proved evidence that the effect of the plea that the suit land was partitioned amongst themselves could be discarded. It was it also appears that Supriya Begum, the mother of proforma defense number 2 and 3, was examined as PW2 has admitted the sale of the suit land to the respondent 1 and delivered possession of the sale land to the respondent 1. Accordingly, this court was inclined to held that the learned first appellate court has not committed an error in appreciating issue number 6 and 7 by holding that a co-owner can sell his or property to the extent of his share. Moreover, as discussed, there is no material to hold that the sale in question was fraudulent and illegal in any manner whatsoever. This is precisely in our case also. There is nothing to show that the agreement was fraudulent, and I have been put in possession. And as I have submitted here before launching, that here it is not a case where other co-owners have come and said, no, this deed was fraudulently executed or this deed was executed without our consent or without our knowledge and selling our share too. It is nobody's case. So, my lord, the first
Yes, Doctor.
my first submission will be that so far as the first substantial question of law is concerned, where the first appellate court committed great errors of law in fact in not discussing and deciding all the issues in the London trial court, being the final court of facts, though reiterated in the appeal. Now, my submission here is that in substantial compliance is what is required. And in this particular case, the learned trial court had discussed the issues of Miller, and the learned trial court finding that there are the other legal heirs did not allow that suit. Appellate court reversed it by discussing all the issues why in a suit for specific performance the parties are not necessary. Only the conflicting parties are necessary, and other issues like whether one party can sign the agreement or not. So therefore, the learned trial court decided all the issues. Appellate court decided all the issues. Because there was more than substantial compliance. So Murugendra has not only been met, there was more than substantial compliance in this case. That's my first submission. So far as my second submission is with regard to the substantial question of number 2. Whether the defendant appellant has the legal right to execute a registered agreement aforesaid in respect of land building to cut a 5 letter covered by that number so and so, when there are many co-partners as owners. This judgment, which I just referred to, approval is now, is on the similar facts of fact, and since I have been put in possession, and my lord, under section 44 also, I have a right, I step in the shoes of the transferor. My learned friend was making this submission again and again that I did not file any partition suit. How can I file a partition suit now? After the deed is executed, if necessary, I can file. But the sale deed has not been executed. So where is the question of filing a partition suit before the sale deed is executed? My basic case is that you have sold this agreement by this agreement, this land. Therefore, kindly execute the sale deed. Possession you have put me. So therefore, my learned friend's second submission that this decree cannot be executed is also not correct. I am already there in possession. And it has been proved before both of the courts, contrary finding of facts. So therefore, the submission that this decree cannot be executed, even if it's not, substantially correct. In the facts of this case, the decree otherwise has been executed, also rather the process has reached at such a stage where I am in possession. Only that is required is that the agreement or the sale deed is to be executed in a proper manner by registering a sale deed. That much only remains. And no other parties in this case had come and said that no, this date was fraudulent or this date was without our knowledge, etc., etc. So therefore, it is the plaintiff now who is claiming after having executed the deed is rather the agreement. He is now saying that no, I did not, I could not have. That is his case. No third party is claiming. So therefore, in my humble submission, the second question under Mohammedan law, as well as under section 44 of the Transfer Property Act, there is nothing wrong. It can always be executed. The agreement could have been executed, and there is nothing wrong in that agreement. Second and third questions are almost similar, because third question is also whether the appellant defendant who executed the alleged agreement with the plaintiff respondent can be asked to register a sale deed in favor of the respondent plaintiff when the land does not retain absolutely in his own name and without making other legal Abdul Qadir parties and without determining his individual rights shares in the suit land. But Kasturi takes care of that. That in a contract will suit for specific purpose or the contracting parties will the necessary parties. Then, my lord, whether in the absence of the findings with the learned courts regarding the genuineness of the agreement for sale and signatures of the appellant, so and the Bainanama, can directly the defendant execute the sale deed to the respondent? This question has been dealt with by the court. And it was not agitated by them in the first appellate court. They did not challenge the sale deed, sale agreement, nor did they challenge the possession deed method. The specific findings, I have read, I can read it from judgment also, is that they produced the weaknesses. The deed was duly proved, the registered agreement for the deed was duly proved, and the possession deed was also duly proved. So therefore, this question also goes, there are other things lordship will taken up 2 or so can take. Okay, that will be 2 minutes.
150.
I'll just take 10 minutes time.
Oh, sorry. At 2 o'clock.
8 o'clock.
Question. Yes, yes.
So for the fourth substantial question of law, I'd just like to point out here that it was whether in the absence of any findings of learned courts below regarding the genuineness of the agreement for sale and the signature of the appellant in exhibit 1, so and so, can direct appellant to execute the sale in respondent. We see page 35 of the judgment of the learned appellate court.
No. Exhibit 1 bears the signature of the appellant.
Yes, no, there it has been proved. The substantial question of law is that whether in the absence of findings, the court has given the findings. It is crystal clear, page 35.
Yes,
So the
35.
agreement for sale registered by NAMA. Then the exhibit 1 has all the attributes of valid and enforceable agreement. For this reason, I do not find the substance of the learned counsel for the respondent. The same is not enforceable by law. So therefore, this substantial question of law, my lord, it's only there. So this has not been correctly framed because findings are there.
Paragraph number 29,
28, madam.
28.
20, last part. It is
Okay.
crystal clear, last five lines. It's crystal clear that the agreement for sale registered by NAMA, that is exhibit 1, has all the attributes of a valid and enforceable agreement. And for this reason, I do not find any substance on the argument of the learned counsel for the defendant respondent that the same exhibit 1 is not enforceable by law. So therefore, he has come to a clear finding that the agreement is a valid agreement. So therefore, this substantial question of law that it was not given, there was no finding given, is not correct. In fact, the trial court also said the same thing. Page 16, para 7. So both the courts gave a finding on their this agreement. And as I had read out, given the summaries of substance, both the courts had read what are the evidences, who signed, who will not execute, who wrote it, all these things they brought in as witness and they will not reduce evidence, saying that yes.
Regarding the finding of the trial court,
Yes,
page number
page 16, madam.
16.
Yes. Para 7, madam.
Yes.
Thus, after going through the evidences of PW and the document under exhibit 1, it appears the exhibit 1, that is the Bainanama, was executed and registered between the parties plaintiff and the defendant. It appears that the defendant agreed to execute the same in respect of suit in favor of the plaintiff after obtaining requisite permission from the concerned authority and received 87,500 from the plaintiff as advance amount out of constitution amount of 1,12,500. The plaintiff number 1. So PW1, plaintiff PW1 also stated that while he made repeated requests for the defendant for performing promise of the sale, the land in question after sale permission, then the defendant, in order to satisfy him, on 31/12/2005 gave a writing marked as exhibit 2, whereby he delivered possession to the plaintiff. So these are the two facts where the court came to a finding. One, the agreement is properly executed, and secondly, the trial court, I'm saying. Secondly, on 31/12/2005, possession was delivered in writing.
Where it is that?
Page 17.
Which part?
First 3 lines, made repeated requests to the defendant
Hmm.
for performing sale, to performing promise to sale the land in question after sale permission. Then the defendant, in order to satisfy him, on 31/12/2005 gave a writing marked as exhibit 2, whereby he delivered possession to the land of the land first. So this is the finding of the trial court. Now, this finding was not challenged in the first appeal by the present applicant. So he accepted that. And your lordship will find that the learned first appellate court also took note of that fact, as I've shown in page 30. That in page 30. Respondent did not raise his remark. Last number 5 lines, 18. The respondent did not raise any remarks by filing a cross objection in the instant appeal, disputing or challenging the said finding of the learned trial court. Below issue number 2, or for that matter, did not challenge the decree passed by the passed in part by the trial court, asking the defendant to refund 87,500. So he did not challenge it. Now, in the second appellate stage, he cannot say that the agreement was not proper. In any case, the fourth substantial question of law is that whether, in the absence of any finding, but contrary to that, the record shows the findings are already there by both the courts. So therefore, this substantial question of law is in fact a non-starter. This one judgment matter which has been referred by the learned first appellate court, that will be relevant because this was the question they raised with regard to execution of deed of the agreement by one party alone. Both the parties did not sign. This has been referred by the London Trial Court, Appellate Court, First Appellate Court. This is Supreme Court judgment, AI 2009 Supreme Court 1527. Aloka Bose versus Procoma Dini. My lord, I'll be referring to paragraph 7B. 7, my lord, will take me on the last part. Plus, this is, my lord, of course, this is the discussion was in connection with one of the judgments rendered by our Honorable High Court. And then, my lord, the Honorable Supreme Court has come to the finding. Para, my lord, 7, last part, my lord. About, my lord, 10, 12 right from the bottom. My lord, there is a my lord, mark here, my lord, that has been highlighted. In the side by sidebar, my lord. Therefore, even an oral agreement to sell is valid. If so, a written agreement signed by one of the parties, if it evidences such oral agreement, will also be valid. In any agreement for sale, the terms are always negotiated and thereafter reduced to the form of agreement for sale and signed by both parties and the vendor alone, unless there is a series of offers and counter offers by letters and other modes of recognition and communication in India. An agreement of sale signed by the vendor alone and delivered to the purchaser and accepted by the purchaser has always been considered to be a valid contract. In the event of breach by the vendor, it can be specifically enforced by the purchaser. There is, however, no practice of purchaser alone signing an agreement for sale. So therefore, my lord, if the vendor, here is the case where the vendor alone signed the agreement, and this is what he questioned in the title appeal. The court has come to the specific finding that a sale deed executed, sale agreement signed only by the vendor is still a valid sale agreement, and the purchaser did not sign it. But if the purchaser only signs it and the seller doesn't sign it, then it's a different issue. Here, the seller has signed it. The purchaser, I did not sign. That will not make it invalid. This is what we tell. Now, para 8, again, last few lines, again, by a sidebar, it has been highlighted. Therefore, even though the draftsman who prepared the agreement might have used a format intended for execution by both vendor and the purchaser, the manner in which the purchaser proceeded clearly demonstrates it was intended to be executed only by the vendor alone. Thus, we hold that the agreement sale was signed by only by the vendor was valid and enforceable by the purchaser. So, my lord, the Honorable Court here came to a finding, my lord, that though it was only signed by the vendor, that is my Leonard's friend's client, my lord, the appellant, it was still a valid agreement because there is no necessity that both the parties should sign. But here, not only does it sign, thereafter possession was also handed over to me. So therefore, there is an acceptance also, my lord. So that this is one judgment, my lord. On the question of acceptance, I just rely on one judgment, my lord. Here is a typical case, my lord, where there's a give deed, and the court held, my lord, that handing over of possession to the donee was also a form of acceptance, because, my lord, here the court has said, my lord, that the vendor, if he executes one side, if he signs it, if he is the only person who signs it and hands it over to the purchaser and the purchaser accepts it, then it becomes a valid contract or valid agreement. Here, the acceptance, that's why I'm relying upon this judgment. Of course, it gives it, but the question is that if I've accepted, how I've accepted, taking over the possession. So that is an implied acceptance. And therefore, by accepting the deal, I have agreed the agreement, rather accepting the possession. I have agreed accepted the agreement, and therefore there is nothing wrong in this agreement, and it is not that it cannot be enforced. This is paragraph 14, it's one paragraph I just read. Single versus separate. Para 14, just one. Here what happened, well, the gift deed was, the possession was handed over to Ronnie. And the Lord, the fact that he had taken over possession, my lord, he has accepted the position, is also an acceptance of the deed, my lord. Or rather, the gift deed there. Here it is a question of acceptance of this agreement, so this has been accepted. And it has not been disputed by them, this agreement has not been accepted. But even then, my lord, it's this judgment of my lord in Alcabos says, my lord, that it has to be accepted also. So this acceptance I'm showing from the position, that there is also an acceptance of the agreement.
Okay,
And
okay.
my lord, payment is another part. My lord. I have paid the money, 87,000. So that is a kind of acceptance of the agreement. But my lord, just 2 points, just 2 more points. My learned friend has relied upon 2 judgments. My lord. First, my lord, our Honorable High Court judgment, where my lord, the refund of money was allowed. RFA, my lord.
Hmm.
That is the case, my lord. Anil Brahma's case, my lord. My
Hmm.
learned friend has my lord relied upon. My lord saying that the court can pass a decree for my lord refund of the money, my lord. Here, the facts were totally different, my lord. Serial number, pair number 40, my lord. Here is the case, my lord, para 40.
Hmm.
Regarding to the case in hand, admitted the plaintiff has not produced any documents showing his financial capability to prove his readiness and willing to pay the balance consideration. It is therefore held that the plaintiff has failed to show that he had been and continued to be always ready to willing to perform his part of the agreement to sale by having the necessary financial capacity to pay the balance of sale consideration amounting to 30 lakhs only. Now here, this is the case where the plaintiff failed to show that he was willing to pay the money. So it is not a case in this. Secondly, my lord, other judgment my learned friend is relied upon Ghulam's sake, my lord.
Mm.
To contain, my lord, this property cannot be sold and things like that, my lord. Lordship will kindly take it to paragraph 3, my lord. The factual background.
Mm.
Here was a case where the third party was claiming, my lord. Paragraph 3. The plaintiff responded. What you got it, my lord? Ghulam's sake, my lord. My learned friend had relied upon the legal propositions, trying to say that the sale could not have been, the agreement could not have been executed. The plaintiff respondent Nandulal claims that he acquired rights in the aforesaid property through his father Saligram, along with his other brothers, and that Brij Mohan, his cousin, the son of his late uncle Sitaram, had no exclusive right to sell the property in favor of anyone, much less to one of the tenants, S.K. Ghulam Lal Chand. So here was a third party challenging the agreement or the right to sell a property to one of his tenants. So under those circumstances, my lord, the court upheld the order of injunction. So therefore, this is totally different background, my lord. In our case, as I have submitted, my lord, right at the beginning, my lord, no third party was claiming that, my lord, the sale is bad. Sale agreement. I'm sorry, my lord, making the mistake again. The sale agreement is bad. It is only that the defendant, after having executed the sale agreement for sale, when it came to the final execution, he got wiser. Perhaps he thought he'll be getting more money from someone else. So he thought, no, better I'll say that there are my brothers and sisters without whom I cannot execute the agreement. So this agreement is bad. So it is his case alone, madam. So under these circumstances, my humble submission is that the first substantial question of law, my lord, has been answered, madam. That is the court has more than dealt with substantial compliance, my lord. Secondly, my lord, co-partners are not necessary, my lord, in this kind of an agreement, my lord, in this kind of a case for specific performance. And my lord, both the courts have come to the finding that the agreement was duly executed. Possession was handed over. There are concurrent finding of facts on both these two issues. Third question also will the same, my lord. Under Mohammedan law, my lord, it can be done, my lord. Under section 44, the transferor, my lord, steps into the shoes of the transferee, my lord, steps into the shoes of the transferor, my lord, and seek partition if necessary. Here I have been given possession. And my lord, fourth, my lord, that substantial question of law, my lord, that it was not, there was no finding by the learned court on the genuineness of the agreement. That's not correct. I've shown that both the courts have given findings. So therefore, in my humble submission, my lord,
Okay.
my lord, there's no infirmity in the judgment of the learned first appellate court, my lord. And the learned first appellate court, my lord, having come to the finding, my lord, that he had executed this agreement and been in possession, my lord, rightly, my lord, directed, my lord, that the specific performance of the contract should take place, my lord, and they should execute the sale in my favor.
Okay. Mr. Mahmood, any reply?
My lord, only 5 minutes, man. First thing, my lord, my learned friend has said, possession has been given,
Hmm.
it is disputed. They filed earlier a suit, earlier a IA.
No, no, disputed means there is a finding of fact by the learned trial court and also by the first appellate court. So you have not preferred any
that
cross
is-
objection against
That
that?
is not clearly mentioned, that possession has been given, only a possession certificate has been exhibited.
Hmm.
That is not clearly given, but they have filed a case recently in 2023. They have filed a case, IS civil number 1853, wherein they said that they have prayed this Honorable High Court, it is on record, that we may be allowed to repair the house. Now, if he has a possession, there is no need to get to take permission from the court, because he was already in possession since the day of issuing that possession certificate.
No, maybe as because the case is pending before this court, therefore they might have preferred the
may be.
application.
That I leave with your lordship. Then lordship may kindly say, one, possession is disputed, that is, we do not admit, even today also we are in possession. We are in possession. Financial issue regarding that judgment, which my learned friend said him, what judgment I have given to your lordship, Anil Brahma,
Hmm.
the other day. Financial issue, court does not deliver its judgment on the basis of what party has money, what party has not.
Hmm.
Court will issue the judgment as per law. So that is not applicable.
No,
in
no,
this case.
that's all right. But there are some decision of the Supreme Court that you have to establish that you have sufficient money to get the sale deed executed in your favor.
No, that was, my lord, repeatedly issued advocate notice.
Hmm.
In that case, that we are ready to get the salary registered in due. In that case, if your lordship may call for the record, there is also repeated request as well as advocate notice was also there.
Hmm.
But thing is this, my lord, due to political change,
Due to
political change was there.
political change.
Political change was there.
Mr. Mahmood, here we are not concerned with political change.
That's why, my lord, things have become a different.
Hmm.
My last submission is this regarding substantial question of law.
Hmm.
A reported case we have given the judgment.
Hmm.
2014
Hmm.
13 SCC 277 para 17.
Hmm.
Here it is clearly mentioned that substantial question of law can be reframed at the time of hearing.
No, if the court feels that it is necessary,
That
not
was also-
otherwise.
That was also our case. The other substantial question of law may be submitted or formulated at the time of hearing.
Hmm.
So, if that some law points are not formulated
Hmm.
as substantial question of law, substantial question of law is what? Which is debatable, not decided earlier.
Hmm.
Now, not decided earlier.
Hmm.
The Honorable Supreme Court has said,
Hmm.
not decided earlier, but debatable question, a
Hmm.
legal question.
Hmm.
So here, debatable question is that he has no power, he has no land, he has executed. Now that's why court said that
No, then how can you hand it over the position?
possession, my lord, that is possession certificate is there, just like
And
agreement.
what more document is
Just
required?
like agreement, but there's agreement, but he has no land.
Hmm.
That similarly, certificate was given because he was in precarious condition, perhaps. That so I leave this judgment is very much important in this case. If necessity arises, then 2014 13 SCC
No,
277.
necessity arises means it must flows out of the impugned judgment and decree passed by the learned first appellate court. Can
And it
you
is
demonstrate before this court that
enough.
any such question flows
The
out
trial
of the
court did not
impugned
say,
judgment
trial
and
court
decree?
said that trial court in para 8 It was clearly said,
Hmm.
and also in page 17, it is it is evident that plaintiff-
Moreover, Mr. Mahmood, whether position is handed over or not handed over, it is a question of fact.
Facts.
It is not a substantial question of law.
No, not that is not. Now, here, my lord, here, page 17 for a moment.
Hmm.
I invite your lordship, page 17, bottom.
Yes.
Page 17, bottom.
Yes.
Thus, it is evident that plaintiff did not inquire and verify
Hmm.
about the suit land, which the defendant proposed to sell him, and to submit before the court in respect of the present status of the suit land, to substantiate that the defendant alone has right over the suit land in order to sell. As the suit land is not mutated alone, specifically in the name of defendant and other pata that are still existed in the suit pata number 62, it will not be appropriate for the court to grant a decree for specific performance of contract. So the judgment of the Honorable Supreme Court has otherwise reflected in the landed Munship's order. Worship would kindly get this is very serious observation of the court.
Hmm. Hmm.
As he did not inquire, and the land is still exists in the name of other persons. Now, my learned friend said that if I get registration, then only I will file petition. That is not the law. When I have filed WS, I have disputed. At that time, it was his duty.
Can I file a petition?
At that time, it was his duty to file a petition. And he is now disputing. So it is not that after registration, you will get registration only if I have land. Now it is not proof that I have land.
Okay. Okay. Heard. Mr. Mahmood, learned counsel for the appellant. Mr. M. Dotto, learned senior counsel assisted by Mr. Learned counsel for the respondent. We'll keep the matter as further, but on that day we'll deliver the judgment. Recessal is the matter as further on. Yes, 12 of June.
12/6.
Okay, record to পঠাই নিদিব এইটো।
Timing item 9.
December.
In this case, I am the defendant appellant.
Yes,
On earlier occasions, my part has already been heard,
yes,
and I have already submitted the corrected required decisions. And after
Yes.
that, after my submission, the respondent was had made their submissions, and they want to file some documents.
Hmm.
That some original documents they have taken time.
Hmm.
The main to refresh the memory of this court, to brief X, I think it will be required.
Hmm. Hmm.
Ready?
First meeting.
Yeah, we could do it. Your lordship,
Format questioning.
the suit has been filed by the plaintiff on the basis of some documents, and the honorable trial court, while giving the judgment, has dismissed their suit. They have sought for a declaration of title, recovery of position. We are in position earlier. And on the basis of some document, mortgage deed, exhibit number 1, and one receipt, there is no valid sale deed. And accordingly, the learned trial court has dismissed their suit due to fail to prove the case. So against that order, your lordship, they have preferred an appeal, and the learned appellate court has reversed the
judgment of the trial court and decreed the suit. And against the appellate, the first appellate court, I have preferred. On perusal of the said judgment, it seems that without having any valid title, how the learned appellate court can decree the suit? They don't have any valid sale deed. I've already made, I think court is aware also. Your lordship, it will go through the judgment of the trial court.
No.
Is
Okay.
there issues your claim
Yes.
whether whether there is any cause of action for the suit, whether the suit is barred by limitation, whether the suit is dead for non-jointer of necessary party, whether the plaintiff has any right, title, and interest over the suit land, whether the plaintiff was in possession of the suit land, and defendant have dispossessed the plaintiff from the suit land, whether the defendants are protected by the light of adverse position. In this trial, during trial, the suit has been filed by the plaintiff stating that they were having right title that one over 10 lessons of land, one Sodesha that has mortgaged his property in favor of the plaintiff and by a registered deed, and accordingly thereafter a sale deed was executed, and they according to them that they have placed the sale deed before the sale register, and due to the small portion or due to non-mentioning of some in the schedule, non-mentioning of dozen butters, the sub register did not register the sale deed. Their claim is that, and thereafter the said Sodesha Das, who was supposed to be the owner, has given a sale deed in return, that exhibit 3. On the basis of, after finding these issues number 4 and 5, that is a very important thing. Our submission in our written statement that prior to 1974, it was under our possession, and that Sodesha was ill, and we have helped, and by way of adverse position, we have been possessing till date of dispossession, till the date of dispossession by the plaintiff, by on the basis of a unregistered, on the basis of not a valid sale deed, they have taken the, with the help of the executing court, they have dispossessed us as of now, in spite of having a status quo from this honorable court. In issues number 4 and 5, the learned trial court, your lordship, it has been specifically stated, according to the plaintiff, one Sodesha the mortgage on 22,474 about 10 lessons of land. Main dispute is regarding the 10 lessons, along with 4 rooms to him for 3 years for consideration of rupees 2,500 and delivered possession of the same. Thereafter, being need of urgent money, the same sold the same to the plaintiff for consideration of 70,000 and executed sale deed in favor of the plaintiff on 5,000,074 and presented the same for registration in the office of the sub-register Gauhati. According to the plaintiff, an area of 10 lessa was small. The sub-register declined to register and kept the same pending. Exhibit 1 is a copy of the sale deed, your lordship, executed by, that should be exhibit 3. That is a mortgage deed, not exhibit 1 is a mortgage deed, according to their executed document, and exhibit 3 is the sale deed, according to them. Exhibit 2 is the receipt. Only their receipt is there, according to their claim of the sub-register. As per your lordship, it has been specifically stated that as per the section 17 of the registration case, if the value of the immobile property such as land is 100 rupees and upward, such document must be compulsory registered. But it appears from
Mr. Sohore,
yes, sir,
on the other day, you have completed your argument.
yes, your Honor.
So, no, there is no requirement to reopen the same.
Yes, your Honor.
Let Mr. Das argue. the
Yes, your
matter.
Honor.
Issue number 4 and 5 only, my lord. If the person come to the appellate court,
Page number?
page given for
Affidavit court charges. Case 6,
Page number?
I think the page number 9, internal page 4 will be the, or page number 6. Yes, well, 9, internal page 4. Main operative procedure. No, appeal memo.
Yes, internal page number?
The main operative 4. So, open the main operative.
My appeal number is only this much. That's why I got this correct.
Okay. That certificate copy is available with the record?
I got a certified copy.
Yes. Paragraph number?
If you watch it from the beginning, it will make something more clear.
Okay. Para number?
From the beginning,
Okay.
otherwise, it's declared that this appeal is preferred by the appellant plaintiff challenging the judgment and decree dated 35/7 passed by Smithy B. Khetri, Learned Municipal Number 2, Gauhati, title suit, dismissing the suit of the plaintiff by the learned. Well, the judgment, it happens this way, madam. So, suit it's regarding was filed by us. Suit has been dismissed. Appellate court has reversed the order and allowed the appeal. They preferred an appeal. Well, in the suit, they have come back like a 5-year written statement. Inter alia stating, then placing their own case. Against that, my lord, the suit proceeded, issues were framed, we file our evidence, exhibited documents, they failed to cross-examine us. Neither they filed their evidence. My lord, they, to look into this, the law is very clear. They have got no case at all to defend themselves. It's now on my part whether I am able to prove my case or not. That's only your lordship will have to look into it, my lord. Issue number 1, 2, 3, I think has been it's in our favor. 4 and 5 is against us, which are the most vital issues. And rightly put it under my friend. Now, my lord, if your lordship comes to page 4, page 4, my lord. Page 4, my lord, now, if it was internal page 4 of the judgment.
Got it.
Now, during the hearing of the appeal, learned counsel for the plaintiff appellate because stating that bearing issue number 4 and 5, other issues number 1 to 3, as well as 6 are decided against the defendant by the learned trial court. And the issue number 4 and 5 regarding the right, title, and interest of the suit land, as well as the possession of the plaintiff of the suit land was decided against the appellant plaintiff by the wrong notion by accepting exhibit 1 as an unregistered candidate. This is very important, my lord. And finding to this effect has also been come by the learned first appellate court. Now, my lord, exhibit 1 is never an unregistered candidate. It's a registered mortgage deed, my lord. It's a registered instrument. It's a registered. Why I'm pointing out the register? I'll place the facts, my lord. Which was denied to be registered by the registering authority, finding small quantity of land measuring 10 lesa, only a receipt of the registration was given to the plaintiff by the sub-registrar Gauhati. This has been proved, madam. The receipt obviously. It is the argument of Mr. Kolita that all the legal issues are decided for the plaintiff appellant and against the defendant respect only because of 1%, namely, all thus cannot be examined by the plaintiff appellant. The suit cannot be discarded in total considering the factual situation of the matter and the decision on the issue of 4 and 5 are found to be the crux of the dispute pertaining to the present. Matlab, in our claim, we have stated one portal dust, but fortunately or unfortunately, we as in the witness, we have not given this evidence. But the learned trial court, while delivering the judgment, did not take into consideration, my lord, while in the PW2, my lord.
Yes.
PW2, we have given a witness. He went to give as a witness as a PW2. He went to the police station to file an FIR for disposing us from the property, my lord, with regard to 10 less hour plan. And with regard to the all evidence, no cross examination took place. So my lord, my evidence stayed. So my lord, learned trial court coming into a finding that we have not examined what total dust for total dust was not correctly in fact, my lord. Because no discussion about the PW2 or PW1 or any other witnesses, my lord. This will have to be taken into consideration while passing the first order by the first appellate court, my lord. Number one, in the result, the appeal having made it, it is allowed on contest. The judgment passed and decree passed by the London court under CLA in the present appeal is said that, my lord, I'm sorry, my lord. Upon perusal of the certified copy of the judgment under silence passed by the London trial court, as well as evidence used by the plaintiff side during the trial of the original suit and the documents submitted by the plaintiff appellant during the next, it is found that exhibit 1, the mortgage deed was exhibited and it was registered properly, and exhibit 2 found to be the receipt given by the sub register office dated 5/11/74. Exhibit 3 found to be one agreement dated 4/12/24, where Soteshwar Das and Bhavananda Das, which is found to be a custody of selling the land of 10 lesser by Soteshwar Das. Exhibit 3, my lord, it has been clearly stated that the hall has been handed over. Mortgage is also safe. Exhibit 3 also is safe. The hall has been handed over. But I got the original. Referred to. This is the original. But what?
Yes.
Exhibit 3, my lord. Last one, Ajipura more ঘৰ আৰু মাটিৰ কোনো শৰ্ত নাই। এই ঘৰ আৰু মাটি মই কেতিয়াবাই প্ৰৱেশ কৰিলে অনিয়ম মতে
আইন মতে
দমদমীয় হম। মই নিজে বৰাবৰক কি কয় চৰাই গৈ 10 কেঁচা মাটি দখল চমজাই দিলো। এই দলিলতেদি সম্পদে কৰিলো। This is my lord, 4/12/74. Now down, my lord. They are saying that they were in the position tribal 1974 is not based on facts, neither on evidence or neither my lord in the critics, my lord. Because my evidence says, my lord, my documents never cross-examined. And why their written statement cannot be taken into account, I also place husband, my lord. So, my lord, the first appellate court has rightly come into a finding that first and foremost, the mortgage deed was not a sale deed. And it's not an unregistered, it's a registered deed, my lord. Moreover, that mortgage deed till now is not under challenge by any one of the legal layers of the original land order, my lord. The pursuit of the decree, we have been handed over the property. Its possession has been handed over. Now you are possessing, my lord. My lord, they failed to prove regarding their title, my lord. Neither any counterclaim or neither till date any suit has been filed by them to say that they have got the right title interest or something, my lord. My right title will be challenged only by the rightful owners if they are equipped, my lord. Because by the virtue of the mortgage deed, property has been handed over. The contents of the mortgage deed is clearly stated. Failing registered sale deed. We have gone there to make the sale deed. Unfortunately, due to the 10 lessons of land, the registration of the sale deed could not take place, but receipt has been proved. Receipt has been proved. Hello. Katsa did, but upon prohibition of original landed procedure found to be a mortgage deed in Sodesha Das and Bhavananda Das 2024, and it is not a sale deed prepared by the seller due to the plaintiff before the sub-register office. Bearing the receipt bearing serial number 1015, exhibit 2, dated 5/11/24. The said deed has never to be proven original. Original can be matter because the sale deed could not took place. Plaintiff as acceptance of exhibit 1 to be unregistered sale deed is not based, it's based on fact, but an imaginary one. So any sale deed executed by the plaintiff is left to be proved in any manner in the proceeding of the original suit. And finding of the learned trial court of exhibit 1, mortgage deed is a unregistered sale deed present by the plaintiff before the registration authority with the registered receipt of exhibit 2 dated 5/11/74 found not tenable, and the issue decided on the basis of the same fact found to be having a wrong finding upon which decision arrived by the learned court found not correct and not tenable in law, my lord. In the result, the order passed by the first trial court has been set aside and the appeal has been allowed, my lord. My lord, first and foremost, my lord, rightly or wrongly, there is a registered instrument, my lord, to give them a clear track that my registered instrument is putting obstruction on them. It need to be cancelled, either way of counterclaim or either way of a new suit, my lord. That till now has not been challenged. It's still in existence. Neither by the legal heirs of the Sadar Sardas or neither by the defendant in the present appellant, my lord. This is number one submission, my lord. Secondly, my lord, they cannot rely on their pleadings because they fail to, my lord. My lord, I'm relying on decision, my lord, 2010, 10 SCC 5 and 12, my lord.
They have not adduced any evidence.
No, my lord. Para, if you lordship come, my lord, A, B. That first becomes,
Paragraph number?
para, before that, my lord, C, in the front page, my lord,
No,
A and
they-
B
they-
evidence.
Those are head notes. So
My lord, para 14. Page 521, sir. But if you lordship come in with the other.
yes, that is not the ratio of this case.
Yes, madam.
That is another decision.
No, my lord, no, madam. First and foremost, my lord, they have filed a written statement. They have not filed their evidence, my lord. So, my lord, the case stated by, set up by them cannot be taken into account. my
No,
lord.
that's
If
all right. But
adverse presumption is there, my lord.
what is the finding of this judgment?
No, my lord, I'm just saying the ratio first of my lord. It says, my lord, when a party pays suit does not affect.
No, that is not the ratio of this case. That is the ratio of that case.
Yes.
That is Bidyadhar, okay, Bidyadhar versus Manik Rao.
Manipur versus Hattar Singh.
Yes.
While deliberated the judgment, my lord, this
Where is the finding of this decision?
Yes, my lord.
In
Em-
this decision,
my lord,
where is the ratio?
If you lordship not evidence, it's something 141G.
No, that's all right. I am asking you. You have referred this judgment.
Yes, my lord.
Mankur dead, which is bracket dead by LRS versus
Yes.
Porter Singh
Yes,
Sambhav.
yes.
Where
In
is
that
the-
case, my
where-
lord, they have relied on this judgment, my lord. in money core versus better thing.
Where is the
The-
finding of this, this decision?
If you for timing, if you come to this para 14, I just have to read out my document.
I have already told you, para 14 is the ratio of a different case,
But
not of this case.
Yes,
That is also relevant in your case.
yes, my lord. That's why I'm saying, my lord.
Uh,
The law says, my lord, section 114 for J, when a
That's all right. There
But
is
it
no
was
dispute
so-
about it.
my lord, their statement that they were in possession, they were holding of the land, we dispossess them, cannot be taken into account because the written statement is not supported by the evidence, my lord.
Hmm.
So this judgment says, my lord, when a party does not appear in the witness box and state his own court, on oath does not offer himself to be cross-examined by their side, a presumption would arise that a case set up by him is not correct, my lord.
Hmm.
It's very important in my case, my lord.
Hmm. Yes.
The first and foremost, my lord, that this judgment totally helped me in this way, my lord. The written statement filed by them cannot be taken into account
Hmm.
because no evidence has been laid down or they failed to be cross-examined by us. So presumption under section 114G of the evidence can be taken against them, my lord.
Hmm.
So they cannot say that they failed to prove that they were in the possession of the property prior to 1974. Now it's my exhibit 3, my lord, clearly says that Sodeswar has handed over the property to us. You are in the position, we has been dispossessed and we have filed a suit, my lord. Because till now, the legal heirs of Sodeswar has not come forward challenging this mortgage property, mortgage instrument or the my lord exhibit 3, neither by them by my lord. And by virtue of the decree of the appellate court, my lord, we have been handed over the property. The suit property, my lord.
Yes.
Moreover, my lord, the law is very clear. When there the legal instrument is there, my lord,
Hmm.
and if it is creating an obstruction of giving a clear title to the other side,
Hmm.
so my lord, that instrument will have to be cancelled.
Hmm.
I also provide the judgment. Today I don't have, my lord, tomorrow I'll come and hand over. One is 2009 and other is 1997, my lord.
Hmm.
Two judgments is from the Honorable Supreme Court
Hmm.
and one from this Honorable Court, my lord.
Hmm.
Three judgments is there, my lord. It says that, my lord, it will have to be cancelled. If it is not cancelled, and it is a legal order from giving them a clear title.
Hmm.
So that is also come in my court. Rightly or wrongly, my lord, this is a research instrument. It is yet to be cancelled and it favors me, my lord. It is still here, it still exists. And the basis of exhibit 1 and exhibit 3, we have been handed over the property, my lord. And our trial court on the wrong finding. Because not taking into account of, neither discuss the evidence of the PW's, my lord.
Hmm.
Has dismissed the suit. And this honorable, my lord, the first appellate court rightly has allowed the appeal, my lord. No, my lord, that is also there. Thirdly, my lord, once when he said that, my lord, that this is suit is based on this, the onus already shifted to, my lord, the defendant to prove that these were not the legal documents. It is part under our law or it cannot give it legal effect. They failed to do so. either by cross-examining these documents or my lord by laying their evidences, my lord. So my evidence still exists, it still stays, without being cross-examined, my lord. Moreover, my lord, since the WS cannot be taken into account, my lord, defender is a stranger to this Scotland, my lord. He'll have to come and he'll have to prove, my lord, what right he has got in the Scotland. Because, my lord, with regard to the possession, my documents prove. With regard to the seal deed, my lord, whether it is unregistered or registered, it will be taken into account. My lord, the property has been handed over and still with it is
Now we have come to the substantial question of law.
Yes, sir. Let me sketch to us. Registration, my lord, though it is necessary, it's above 100 rupees 100. My learned friend is very much right here, my lord. But, my lord, with regard to the registration, my lord, we have proved the receipt. That has not been, my lord, taken into account while passing the judgment by the trial court, my lord. We have gone there for the registration could not take place due to the 10 acres of land.
No, whether
my
the quantum of land
Yes, my lord.
or the value of the property or value of the land is irrelevant.
My lord, if your lordship also take it this way also, my lord, if your lordship come into a finding that this land is not registered one, my lord.
Not registered.
Registered one, my lord. If it is not registered one, my lord, we are in the property. It will have to be challenged by whom, my lord, by the original landowners, my lord. They have till now not come into challenging this, my lord. The mortgage deed is there. My lord, my exhibit 3 is there. By virtue of we are in possession till now. That cannot be denied by my friend, my lord. So, my lord, if your lordship exhibit 1 and registration is in absence of valid sale deed, if your lordship also come into a finding that's not valid sale deed, but my possession cannot be taken away. Because I have been handed over possession. No right has been acquired to them. The right will have to come from the original layer. Till now, it is not under challenge. It's a registered instrument, my lord. Rightly or wrongly, it's a instrument, it still exists. And I will provide the judgment, my lord. It says if it's creating a legal obstruction, my lord, it'll have to be cancelled. That has not been cancelled till now. Possession is here. My on the virtue of this instrument here in a possession, my lord. So, my lord, the substantial question from my is no finding in this appellate. So, my lord, the appeal does not deserve any merit be dismissed. And if the lordship allow us, both of us, submit a written synopsis of our argument, we can provide in 2 or 3 days, my lord. This is helpful,
Okay,
sir.
we'll list the matter on next Friday,
Next week, but
next week.
next week, let it be partner matter. Because
Wednesday, no, Tuesday then.
Yeah.
Third is also today.
I want to reply you little bit. Regarding some submission made, you know, they have filed a suit. The prayer made in their plea. It is At page 31, it is the plain file back. In the prayer portion, your lordship, they have sought for a declaration of right title over the suit land. On the basis of three documents, your honor, one mortgage is registered according to them, and recovery of delivery of possession.
Yes.
They are telling that from the time immemorial they were in possession, your honor.
Yes.
In the written statement, we have already stated, prior to 1974, prior to execution of their so-called mortgage deed. And after mortgage deed, what made if they want to say that the mortgage deed is a safe transfer document, then what made them to execute another sale deed, so-called sale deed? If they think that the mortgage deed is the safe transfer document, what made them to file made another deed, unregistered deed, so-called agreement? And they want to say that receipt is a transfer document, your lordship. They want to say that a sub-registrar did not record it. Whether it is not their duty to, at the time of evidence, to call for the officials of the sub-registrar to prove their case that for that reasons that sale deed could not be registered. It is not their duty because I already made my submission in decisions. The burden of proof always lies upon the plaintiff. It has in the decisions, your lordship, 2014, I have already.
No, you, instead of replying, you are reopening the matter again.
Yes, because they are stating that
No,
we are
no.
not in possession.
No.
That on the basis of a mortgage deed, it has to be transferred. Your lordship, property has been transferred. You know, section 54. of the-
One by one.
Let me finish. Your lordship, section 54 of the immovable the transfer of property specifically stated that sale is transfer of ownership. Sale how much? Sale transfer in case of tangible immovable property 100, below 100 and upward. Registration is a must. And from their mortgage deed and from their own submission, it says that it has been mortgaged around 2,500 and sale deed he had paid around 70,000. So property has been valuation, they have been stated. So valuation 100 and more, it is under section 17. Whether at this moment, whether they have a valid sale deed. So that substantial question has been framed to that effect, your lordship. And learned trial code also, section 17. The earlier appellate court, your honor, even though the appellate court had stated that sale deed has not been proved, even then also it has decreed the suit. It has been stated. Plaintiff has not proved the sale deed. In spite of that error has been done, your honor. The appellate court judgment, it has been stated that case, your lordship. So sale deed, so any sale deed allegedly executed by plaintiff on factors are left to be proved in any manner in the proceeding of the suit. Even appellate court has also admitted they have totally failed to prove their own document, and now they are putting a burden upon us that it is our duty. Is it not the duty of the plaintiff? We have in a written statement, we have preferred that prior to 1974, before execution of the deed, we have been possessing by right of adverse possession. And on the basis of without having valid sale deed, your honor, by misleading the executive court, even after there is a status quo order passed by this honorable court, they have taken possession by this, and now we have been dispossessed. That is the main crux, your lordship. So that substantial question which has been formulated. Whether the first appellate commit any illegality in reading the trial court finding of compulsory registration of an instrument. So that has not been done, your lordship. The trial court has rightly passed the order, your lordship, by rejecting their suit. And whether the learned first appellate committed illegality in deciding the suit on the basis of a mortgage deed. You know, nowhere in the mortgage deed it has been stated that possession was handed over to the said plaintiff, there is not a submission.
No, that exhibit 3 is there.
Your Honor, exhibit 3 is
Yeah.
an unregistered, Your Lordship.
Mm,
It is not a registered document.
mm.
That has to be looked into, Your Honor. If anything can be written, Your Honor.
Mm.
It's an unregistered document, Your Honor.
No, signature is there.
That is Your Lordship regarding the position, it is not the thing. First of all, title has to be, they have to
Mm,
satisfy the title over the land, Your Lordship.
mm.
We have been possessing prior to 1974, already it has been stated here with the statement. First, the burden always lies upon the plaintiff to prove his own case regarding the title, Your Lordship.
Mm.
And regarding possession comes later on, Your Lordship. First of
Mm.
all, title, they have to prove their case. Because they have claimed, they have filed the suit on the basis of title. There was thus has one executed one mortgage deed and thereafter another sale deed, one
Mm.
receipt. These are all fake submissions, Your Lordship. We have denied in our written statement. And on the receipt,
No, you may deny in your written statement, but you have not adduced any evidence.
Your Honor, that was earlier it was due to some parties default. That is a
So
default. Your Lordship.
your written statement cannot be taken into
Yes,
account.
yes, that is true, Your Lordship. First of all, Your Lordship, a judgment has to be delivered
Mm,
on the basis of the plaintiff's case. Even expertise judgment, also, Your Lordship.
mm,
If court has to give a decision to that effect, whether on what pleadings the plaintiff has claimed, whether it has satisfied or not,
mm,
whether the title has been proved or not. These two decisions has been has reflected everything, Your Lordship.
mm.
Like in even expertise judgment, in expertise order also should has to is dismissed because plaintiff cannot fulfill the title, Your Honor,
Mm.
criteria of the suit.
Mm.
So in that case, if it is presumed that it is an expertise judgment, first of all, if it is dismissed, the trial court judges, they have to say that what trial court error has done. Trial court have error.
Mm.
They have not stated that their sale deed is or their mortgage deed is equivalent to sale deed. They
Okay.
cannot say, Your Lordship.
Okay.
So my humble submission, Your Lordship, is that the trial rightly passed the trial judgment has been passed by the trial court, and the appellate judgment is not in proper form. Error has been.
Okay, all right. Heard Mr. Soudhuri, learned counsel for the appellant. Argument concluded. However, Mr. Das submits that he may be granted some time to file a written argument. They are allowed recess and raise the matter as further on next Tuesday.
Next Tuesday. First, next Thursday, madam. 11. Next.
Yes.
It's
11 June.
Okay.
obliged, madam.
15 order maker.
Was heard on the other day. It relates to penal demarriage charge imposed upon me, Lordship, without following the prescribed procedure, Lordship.
Counsel for the other side.
Lordship, he was here, Mr. CKS Borua was here.
Then he left at lunchtime. Told me that he's not feeling.
So he left the court premises.
That is not known to me.
Heard Mr. MP Sharma, learned counsel for the appellant. None appears for the respondent on call. List the matter.
Lordship, in the next week, if possible. পাহৰি যাব ন পাৰে যদি আগত দি দিয়ক পাহৰি যাব
After vacation.
Lordship. Obliged, Lordship. may be kept as part heard, Lordship.
Okay. Raise the matter as part heard after vacation.
Item 16 and 17.
Right, Lordship.
Lordship, in the last order dated Lordship 9/12/25, there was a direction to furnish the copy of the paper book to the councils appearing for the state of Nagaland. And Lordship, and it should have been Union of India. It's here, it's written wrongly, Lordship, Government of Assam, because Government of Assam is not a party here. And moreover, Lordship, there were certain defects in the paper book which was furnished to us earlier, Lordship. That was also to be rectified, Lordship. Now, what we find in the paper book that there are 2-3 pages which are not legible, Lordship. Lordship, the Lordship may peruse the order dated, Lordship, 9/12/25, and the earlier order before that, Lordship, that was on 28/2024, Lordship.
No, this is a regular first appeal.
Lordship.
What is the question of preparation of paper book?
It has come up. Book to book. And,
You were the appellant.
Lordship.
You were the appellant.
Lordship. And in item number 16, my learned friend is the appellant, Lordship. 17, Lordship.
On subject to correction on 13/3/2019, there was an order from this court.
13/3?
13/3/2019. Of course, at the time, both of you were here. Subject to correction 13/3/2019. Some delay was there, that was gone, not subject, and this was there.
Whether our High Court rule provides for preparation of paper book in a regular first appeal. Paper book is usually prepared in criminal appeals.
Civil court also be done. It is
Already prepared. Now, you are not ready to argue the matter.
Now, Lordship, as per last order, as per in the paper book, there are some pages, Lordship, that is not legible. So once we were directed by this honorable court to go to the registry and show the defects, and accordingly we had gone there also, Lordship.
We had shown it.
Shown to the registry, and pursuant to they had to supply us the rectified copy of the paper book, Lordship.
That has not been done.
That has not been done, and moreover, my learned friend appearing for Nagaland and the Union of India, who are parties here, they are not furnished with the paper book, Lordship.
No, the first question is there any provision in our High Court rule for furnishing preparation of paper book and furnishing copy of the same to the parties?
Lordship. We have to check, Lordship.
Because the order was there prior to joining our to this case.
No, that's all right. The court's orders are there. Now, relying upon that defective paper book, you are taking adjournments. This is of 2005 matter.
Lordship.
Heard Mr. Saxena, learned counsel for the appellant. And Mr.
MK.
Mr. Learned counsel for the respondent number.
One.
Respondent number 1. And Miss Casey for respondent number 4.
Seven.
No, in 138.
138.
In 138, the state of Arunachal Pradesh is the appellant lordship. And in case number 140, my learned friend is the appellant.
Respondent number 7 is Nagaland Lord. In 138.
Or state of Arunachal Pradesh is the appellant.
Lordship.
And Mr. Misra for
140 lordship.
In 138, I am for 1 minute.
respondent Union of India.
No. I think I am for 20 also. I am for 21.
One lordship.
No, in appeal, you were for
Record number 1 is Mr. At that time it is a joint undivided joint family business matter. So
okay. MS Surajmal Kanayalal.
at that time. Now it is after his death, it was abandoned and now Vijay
Kumar Modi.
Vijay Kumar Modi has come up as Kota.
Where is the amended cost title? Hmm? And Miss Casey for respondent number 4, State of Nagaland. And who is for respondent number 3, 2 and 3?
2 and 3 lordship. Not appear.
Not appeared. None appeared. None appears for the respondent number 2 and 3. Mr. Saxena, learned counsel for the appellant, submits that as per direction of this court, the registry has prepared paper book. And there are some pages of the paper book in page number
Page number 79 and 119.
79 and 119 are found to be not legible. And as such, he submits that a direction may be issued to the registry to furnish a legible copy of the aforementioned pages to him and also to the learned counsel for the respondents. Ms. Casey also submits that she has not been furnished with the copy of the paper book.
Yes, Your Lordship, I have not received it, even the defective
Okay.
one.
Registry is directed to furnish a copy of the same to Ms. Casey within a period of 1 week from today. Registry shall list the matter on fixed date before vacation.
On 23rd June.
No, Kobe. Next week.
Next week. 11 June.
11.
11 June.
11 June. Oblige lordship.
19.
19. Respondent number? two.
And for the respondent number 2, your lordship.
Respondent number
Two.
two.
Yes.
Who is for respondent number 1?
Who was initially pro forma defendant in the title suit, lordship?
Pro forma dependent as well.
No, in suit, no one was pro forma defendant.
Can you sir? Inam?
14 newspaper.
Edition. Oh, 14 will be. Respondent number 2.
Respondent number 2 was originally the defendant number 4 in the title suit, lordship. And the main plaintiff is absent to the lordship. Respondent number 1 plaintiff is absent today.
Hilalal Das.
Yes, lordship. He was the plaintiff. I was the defendant number 1 to 3. Okay.
Heard Mr. Sharma, learned counsel for the appellant,
Appellants.
and Mr.
G, yes, lordship. On
G Das, learned counsel for the respondent number 2.
2, yes.
None appears for the respondent number 1, 3, and 4. List the matter after a week. In the event of subsequent non-representation of the aforementioned respondents, the court will proceed to hear the matter in their absence.
Highly applied.
22 and 1 of the.
21 to mention those.
But this is the matter, my lord, where the small issue is there. What had happened is the respondent, who is the plaintiff, filed a suit for specific performance. The trial court, while dismissing his suit for specific performance on the ground that the agreement to sell is not only a forged, but forged money receipts are also given, also holds that I am not the owner also. So the seller is also here, and the buyer, the alleged buyer. So both of us, both the appeals are here. RFA 73 is mine, and RFA 11 is by the plaintiff. 111, sorry. Now this issue needs to be resolved, my lord, because the peculiar circumstances and the vacuum which has it created divested me of my right over the property, which the plaintiff admitted not only in his plaint, in the FIR, in all his depositions also. Agreement to sell also categorically records that I am the owner. The court finds that I have failed to prove my ownership and divest me of my right to over the property. And now, my lord, the property is, my lord, as rightly put, my lord, in mullahs and everywhere, in, my lord, in Mindo. My lord, it is neither here nor there, but they are certainly enjoying the possession since 2013, given it on rent, earning, my lord, more than 2.5 lakh every month over my property, and my matter is also not being heard. And that is, my lord, in nutshell, the entire matter is. And this matter has been heard, my lord, on various occasions, 3-4 times, part heard, then, my lord, released from part heard, and now it is before my lord. And again, my friend on the other side, my lord, called up in the afternoon that he can't come to this honorable court, my lord, today.
May I please, lordship, yesterday only we have received the copy, yesterday last evening, so.
What copy? The copy of the IO? Sorry, this IA.
IA. Yes, lordship.
IA, we filed it because we came to know that they are, my lord, they have vacated all the tenants and they're trying to dispose of the property. So rank strangers, my lord, now own in possession, they're going, my lord, dispose of the property at peanuts. And my lord, then I would be again running after somebody or the other, trying to get hold of the property. And that is the reason at the last stage, my lord, I filed this application, because my matter is also not being heard. All pleadings are there, my lord. Leave was granted way back in 2019. Original record is also here. We have argued it. My friend also has argued multiple times, my lord. Issue is only, first of all, my lord, my appeal has to be allowed.
Why there is no judgment?
Please, my lord.
Why judgment was not delivered or pronounced?
Oh, my lord, on the last, my lord, on various occasions, whenever the matter would come up,
Hmm.
the roster here, my lord, changes quite a lot, my lord, in Guwahati, I believe. And that is why when the matter would come, it may come before some another bench, and then that bench was holding the criminal roster thereafter and would not hear the matter.
Okay, so today you are not prepared to argue the matter.
No, Lordship. We need some time to reply on this.
No,
My
no,
lord,
if
be heard, my lord, be heard or not heard is not the point. The main petition is for hearing. This is for hearing of the matter. I may not even press my IA today. And they certainly can't, my lord, say that.
Okay, let us fix a date for hearing.
Have it tomorrow, my lord, or day after, my lord. I am here because I come all the way from Delhi, my lord, and they are enjoying the property since 2013. My lords may kindly appreciate this fact. My property is being forcibly taken. Police registers a case against them for under Land Grabbing Act. Then the civil court, my lord, with the impugned judgment says I am not even the owner.
Okay. On Thursday, we'll try to hear the matter.
Very well. I'm so grateful, my lord. If it can be only, my lord, top of the board, my lord.
You inform your senior to remain present on Thursday.
IS Mazumdar.
Who?
Appearing on behalf of IS Mazumdar.
IS Mazumdar.
Yes,
Okay, all right.
Well, only if
Mr.
it can
your
be
name,
taken up,
please?
only one small indulgence I may seek, my lord. My lord, if it can be on the top of the board, my lord, I
Okay,
would
we'll
really
try.
appreciate.
Okay. Heard, Mr. Your name, please?
My name is Amanpreet Singh, my lord. Amanpreet Singh Rahul.
Amanpreet Singh, Learned Counsel for the appellant. And Miss, your name, please?
J. Mosam. Lordship.
Learned Counsel appearing on behalf of Mr. IS Mazumdar, Learned Counsel for the respondent. Mr. Singh submits that the appellant herein has filed one interlocutory application for appointment of receiver. Under Order 41, Rule 1 of the Rule 1, read with Section 151 of the Code of Civil Procedure, seeking appointment of court receiver and consequential direction for protection and preservation of the suit property. The learned counsel appearing for the respondent submits that she has received a copy of the interlocutory application yesterday and she needs some time. Here allowed raises all these matters on Thursday as top of the list item.
I am so grateful, man.
Item 24.
May it please your lordship. Your lordship, today I am seeking for adjournment. Can it be fixed on Thursday?
Because this is old matter, also pertaining to 2008 matter. All the cases registered in the 2022. And the hearing matters also I have spent a lot of time for preparation. Currently is praying for adjournment.
Thursday it can be fixed, your lordship.
Thursday
As lordship, it top of the list.
as agreed upon by learned counsel for both the parties. This is at least the matter on Thursday. Let us fix the time at 2 p.m.
Okay.
At 2 p.m.
Much.
Item 29. Sorry, 27.
Lordship, I have filed this appeal on two grounds. One is the cause of death. The other is the quantum of compensation. Lordship. I'll first come to my strongest point in this case. That is, Lordship, Lordship, this is in this case was a retired person, Lordship. And post-retirement, Lordship, he was working in Assam Sarva Shiksha Abhijan Mission, Lordship. And although he was a pension holder, his pension was about rupees 22,000. That amount which he had received from Assam Sarva Shiksha Mission, Lordship, that is in page Exhibit 23, page 97.
B file. C1. C1. Page number?
Page number 97 of the LCR, Lordship, Exhibit 23.
97. '97 is the last pay certificate?
Last page, Lordship.
Yes.
Lordship, he was, I think, working as a liaison officer. The last pay that was drawn by him was in August 2017. And the accident occurred in for 2018, 31st May 2018. He died in 14/6/2018. So this is a post-retirement contractual year. He was not even drawing that amount at the time of his death also. While his pension is something that is, he had earned that pension, it will go on. But there's no pension benefit from this. This is he had earned it for 2 months, 2 years or 3 years. I do not know. No other documents have been furnished. But obviously post-retirement, at the time of death, he was 64 years, 7 months. Now, this lordship amount, I think, in my humble submission, should not be taken for consideration of loss of dependency. Because that amount he had not received. He was not drawing that amount at the time of his death. That was the last pay certificate. That was about 10 months before the accident, Lordship. My humble submission is that this may not be taken as
No. Is it your case that on the date of accident, he was not in service?
He is not in service. There's a last pay certificate. Others, there would have been last pay certificate would have been of the previous month or before that. And there's no other document except this. Not even that letter of engagement, letter of appointment. Post-retirement, normally people, I think, get it lost. In my general the information says that maybe 2, 3, 4 years, something like that. And he was already 64 years, 7 months at a time. And if the last pay signifies that this was not his income at the time of death. He had received it fine, that was a part of his income. But not definitely income. If he had received it before his during service, then this would have been considered.
Okay. Yes. You are Mr. Mishra.
Dr. Lordship.
Doctor. Okay.
Yes, Lordship.
Do you have any other document to show that on the date of accident he was in service of Sarva Shiksha?
No, Lordship, only this document and one this identity card exhibit 22 is in there.
Exhibit 22. Identity card will not do.
There is no date in that.
No other documents, Lordship.
No other document. No, whether in fact he was in service or not on that day, on the day, the date of accident.
From this document, Lordship, he was working till August 2017. From this document itself, Lordship. So in that respect, Lordship, I have to take some instruction, Lordship. If on 19/3/2018 he was in service or not.
And the tribunal has taken note of this certificate.
That
And thereafter
added to the income, Lordship. That has been taken as an income.
And the pension.
Along with pension.
Along with pension.
This paragraph 27 of the judgment is 20 last page drawn, digits from the Assam Service Commission was 14,820, therefore it tells that total income of digits was 42,030.
This is added to the pension.
And paragraph 21, Lordship, in the state judgment.
Hmm.
Now coming to the question of income and occupation of the claimants. The claimant has deposed in her evidence that prior to the accident, her husband Lokeshwar Pura was a retired service holder, and he got retired from his service on 31/1/2014. The claimant upon giving her evidence has deposed that after the retirement, the disease got employment under Assam Sarva Shiksha Vision Mission as BRP. At the time of death, the disease was used to earn 43,000 per month. From this, it was reflected that he was working at the time of death, Lordship. From this judgment, Lordship.
No, if he was in service on the date of accident, the last pay certificate of the previous one could have been produced.
Lordship, that is its documents of that August 2017, this document was before the court.
Accident took place
In 2018, Lordship.
18.
Yes.
31st May, maybe?
31st May 2018, Lordship.
No, that's all right. This document is.
The digit was
You see, this certificate was issued on 19/3/2018.
Yes, yes.
And it pertains to the month of August of 2017.
Lordship.
Mr. Goswami, let him obtain instruction. Whether he was in service on that day or not.
That instruction.
Heard Mr. Goswami, learned counsel for the appellant. Mr. K.K. Dotto, learned counsel for the respondent.
1 and 2.
Heard in part, list the matter on after vacation. After vacation, so as to enable Mr. Dotto to obtain instruction as to whether on the date of accident, the deceased was in service as indicated in the last pay certificate dated 19/3/2018.
Problem, Lordship.
Yeah.
Did you after vacation?
29.
Plus.
Why?
Senior has to leave the court, he is some.
As agreed upon by learned advocates of both the parties, SSL list the matter after vacation.
All right, so let's.
Required for the day, Lordship.
Pardon?
Little accommodation is required for the day, Lordship. Next week, Lordship.
Next week. Okay. Suggested date then? 10th. Call it?
And motion day, I suppose. 11.
On 16th.
16. Okay. As agreed upon by learned advocates of both the parties, SSL list the matter on 16th. 16th.
Let's.
Any